Yes. Serial number 7. One by one. Yes.
Serial number 7.
Yes.
Week for 1 month. Accommodation.
No mention. Yes, madam. Start. You are the first in row.
My lord, this is a
No,
appeal.
from the middle will not permit any mention. It is to be from this side to this side. Yes.
This is a writ appeal, my lord, filed on behalf of the Bangalore University, my lord. This is a matter that came up twice before your lordships for hearing, but it did not reach, my lord. Meanwhile, what has happened is the respondent has initiated contempt proceedings, and the next date of hearing is next week, my lord, on 18th. The matter may kindly be heard, my lord, because without any eligibility,
20th.
it's listed on the 18th, my lord, for contempt.
Contempt is on 18th.
18, my lord.
All at 18th.
My lord, anytime before 18th, if the matter may be
May
listed.
not be. On that day will contempt is coming on 18th.
On 18, my lord, any
18.
day before, my lord.
Not 18th.
Serial number 52, my lord.
Yes, Mr.
Okay. Accommodation. Serial number 7.
Till number 7. All right. 26 June.
My lord, this is a
One petition, my lord. A PIL, writ petition, my lord. It is in respect of the enforcement of the provisions of Drugs and Cosmetics Act and rules, my lord. The respondents were permitted to file a better compliance affidavit. Now they have filed a compliance affidavit. The contentions taken in the compliance affidavit are contrary to law and false, my lord. Kindly be posted for needful action, my lord.
No, it will come.
my
Yes,
lord,
Mr.
this is a 2020 PIL matter, my lord, relating to fixing of fare meters for auto rickshaws. A fresh writ petition also has been filed, which is later to be listed.
Which matter?
WPC,
On board today?
not today, my lord. That is listed on 19/6. My humble request is this case also may be listed on 19/6 so that both can be clubbed together. My lord.
We are not getting. Yes, next. To convey to says the learned court must.
At least
court
memo may
office-
kindly be taken up. Memo may kindly be accepted.
No memo. What we are not getting, what is your request? What is the request, Mr. Party?
My lord, my humble request is already on the new fresh writ petition has been filed, which is stated to be listed on 19. This was filed in 2020, my lord, on the same subject matter. Therefore, my humble request is this case also may be listed on that day so that it can be attached together.
Which one? New one?
Both, my lord.
Where is the new one?
New one is on 19/6.
No. Let it.
19/6.
Yes.
My lords, this is a public interest
We don't know what
litigation.
is the subject matter. Yes, Mr.
My lords, this is a PIL filed by the Lamani Tanda called Takkalaki. The land that belongs to the Tanda community are being siphoned off by the private parties. Hence, I request a preliminary hearing day after tomorrow, that is on Friday, or any other date, my lords may please.
It will be listed. Not by memo. Yes.
Memo,
Your lordship, serial number 37. Today it's morning, so the respond number 3 give wakalat.
37
Undertake to file wakalat for respond number 3, my lord. Today morning they give wakalat. Hence a press time to respond number 3.
So what do you want ultimately?
Adjournment, my lord, or adjournment.
What is saying? What is saying?
The already interim order is there.
Time, all right. 4 weeks. Yes.
Your lordship,
Yes, Mr.
Serial number 52, my lord.
Yes.
your lordship, it's a contempt petition. So the respondent is proceeding to construct the building despite the interim order passed by the learned single judge, your lordship.
It will be listed in due course. Yes.
Serial number 52 today is on the board.
50.
It is for office subjection at the submission of a.
All office of 3 weeks.
Office subject, I want 3 weeks. But in this case, this honorable court has granted the interim order, which has been granted by the learned single judge. Status could be maintained to be continued next date of hearing, till next date of hearing.
We are not continuing any interim order.
It is there already. It is that this honorable court has granted. Division bench of this honorable court has granted.
Remove the office officer. You can't go on getting the relief in interim relief extended under the guise that you are not removing office officer. Remove by tomorrow.
The status could be maintained, which has been granted by the
Maintain
learned single.
status quo if it is granted by learned single judge till you remove the office officer. When you will remove the office officer? By tomorrow.
Obviously, like it means.
No, by not removing office officer, you can't get the relief extended like that.
I can give you 1 week time, I'll do it.
No, do it within 2 days.
Within 2 days.
On Monday.
Interim order to be extended.
Monday. Stand over to Monday, within which time all the office
Not Monday,
officers-
or Wednesday.
Oh,
Because my cousin's
Send over
marriage
to-
is there in Chennai. I have to
send
go
over
to Chennai now.
Today is what?
I'll be back only on 19th or 20th. So my cousin's marriage is there. I come only for this purpose from Chennai today.
Maybe.
So they kindly give it on Wednesday, my lord.
Under the guise of non-removal of officials, you can't get the orders extended.
Yeah, only,
Interim
just-
order.
only for me, 1 week, my lord. I'm not asking further. I
Applications
need
will
only
be
1 week
removed
time, my lord.
On or before 14th of June, full stop. Interim leave stands extended only to until that date, and now and never and not beyond that.
20th, 19th or 20th can give date, my lord.
We
I'll
said
finish
Monday, then you are not.
No, because what has happened, my cousin's marriage is there. I come only for that purpose.
It is by the clerk to remove the.
Because I have to do it, I will not be stationed. my lord.
18.
18th,
Remove the, what are the officials?
I will do it. I will
Type
do it.
copy is to be supplied, translation is to be supplied, court fee is to be paid.
I will do
It
it.
takes how much time? 1 hour at the best.
I will do it within 1 week. That's what I.
Do it by 18. Interim leave granted earlier, shall extended till 18.
Lords, 2023 contempt matter, my lords. My lords, pursuant to an RFA by this honorable court, my lords, the honorable court had directed to pay maintenance to the complainant, my lords. However, not a single penny has been paid to the complainant. Now, my lords, the emergency in this matter, my lords, is that we are unable to take forward our day-to-day activities and we are unable to meet expenses. My lords, may I kindly post the matter for tomorrow, my lords.
What is the urgency?
My lords, we are unable to take forward our day-to-day expenses, my lords. The court had instructed to pay maintenance. The husband is deceased, then the complainant is not able to take forward her day-to-day expenses, my lords.
21st.
My lords,
21st.
much obliged, my lords.
Lord, serial number 18, my lords. The counsel for the appellant is not keeping well today, my lords. Short accommodation may be granted.
4 weeks.
Serial number 3, PL matter, my lord.
Serial number?
3, my lord. Week's time may be given for the petition. The on record counsel is not feeling well. Is in
Not
hospital.
pressing.
My lord.
You're not pressing this. What is
Serial
it?
number 3, my lord. First list. PL matter. Serial number 3, my lord.
3, what do you want? Not pressing. You
No,
know
my
it.
lord. The on record counsel is not feeling well. He was in hospital. He informed in the morning only. I seek for weeks time.
Cooperative.
He was in hospital, my lord. Adjournment, my lord.
Why? But for what reason?
On record counsel has been admitted in hospital, my lord. He call in morning.
All 24th.
Obliged, my lord.
It was stated that the counsel for the petitioner is hospitalized. Is in indisposed health. Since the time is requested on such grounds, stand over to 24th of.
This is memo contempt case, my lord.
Hmm?
There is a direction from this court to Revenue Department to open the RTC in my name. Since they are not complied, because adjacent land is of BDA, they are encroaching my property.
Not by memo, it will be listed. Yes, sir.
Can permission. Contempt matters. Still number 1, start going right.
Complainant. Lord, the complainant and the respondent,
What is the contempt?
Lord, by mutual consent decree, Lord, divorce was obtained between the parties. Custody was to be with the complainant in Bangalore. Lord, the accused takes the children to Chennai for vacation, summer vacations, as part of what was provided in the decree, and refuses to bring them back to Bangalore.
You are for?
I am for the complainant mother.
Mother.
Yes.
So where is the direction?
So at page 30, my lord, is the decree of the page 19 is the decree, page 30 are the terms of the agreement between the parties. Page 19, copy of the judgment, my lord, in page 19, the last paragraph married, 19.
19 or 23?
Not 19 is the judgment of the family court.
It starts
May
with 1.
I read the last paragraph, my lord?
Yes.
Both parties have 2 children, daughter by name Kadambari and son by name Skanda, presently under the care and custody of the first petitioner mother. The first petitioner shall have custody of both minor children until the second petitioner relocate.
Here, earlier listed.
It was listed day before yesterday, my lord.
Why it is?
I had filed a habeas corpus petition also to retrieve their custody. But in the habeas corpus, when children were brought to the court, and the daughter, my lord, expressed her desire to continue to live in Bangalore with the mother, and custody has been, my lord, now handed over to the
Order
mother.
is passed?
Yes. May I place on?
Yes. So ABS was filed by you?
Habeas was filed by me. The relevant portion, my lord, is the second paragraph from the bottom of the page, my lord. We have also interacted. Your lordship has it. the second paragraph from the foot of the page. We have also interacted with both the children.
Which order to be seen?
Not the order dated 10/6 to 2024.
We don't have the system of the copy from the computer. This is too small. Which order? Which order is shown?
The
Date,
web-
or date of the order?
10/6/2024. Day before yesterday. May I read the penultimate paragraph of on the left-hand side? We have also interacted with both the children. The elder child, Kumari Kadambari Subramaniam, submits that herself and her brother were taken to Chennai for summer vacation, and her father got them admitted in the school at Chennai. She expresses her desire to study at Bangalore only, having considered the opinion thus expressed.
Then what will survive now?
Not the violation of the order, my lord.
What violate?
The
Now
conduct of the father, my lord, in taking the children away and not bringing them back until this
the
honorable.
custody is with you by virtue of this order.
I'm sorry, my lord.
The custody of both the children is with the wife, mother,
Temporarily, my lord. Only
your client.
yes. Now, my lord. Yes.
So then what survives in this?
My lord, he cannot purge himself of the
Act can't be for the sake of contempt.
My lord,
And it is not today existing, the contempt is not enforced
my lord,
by nobody.
may I make only one submission, my lord, for your lordship's kind consideration. My lord, a person, my lord, who violates a judgment of the court and refuses to bring the children back to Bangalore, my lord. Thereafter, this honorable court was pleased to, my lord, record
Can't exercise the contempt jurisdiction that lightly in every this and that matter. Now custody of both the children with the mother with you, what is the contempt now? Nothing survives.
my lord, but for the order of this honorable court, my lord, he would not have brought them back, my lord. And the order of the honorable court says, my lord, it's
Take matter of this contempt.
may I make this request, my lord? In that case, my lord, having regard to this order, I will withdraw the contempt.
Having regard to the order passed in the habeas petition whereby the custody of two children is handed over to the
Mother,
petitioner mother as per order passed by the coordinate bench on 10/6/2024 from a learned counsel for the learned counsel and so and so and so for the complainant seeks permission to withdraw the present contempt petition. Permission is granted. Disposed of as withdrawn.
Obliged.
PL matters, syllable 2, Shanumanta Pabi Arigowda.
My lord, a very important petition, my lord. My lord, the petitioners have filed this petition before this honorable court, taking a mandamus against respondent 246 to consider representation. The six are constructing the dry wastage unit in the Goman land that affects the health of its villagers. Therefore, till date, no action taken by the response, my lord, 246. And it is a, my lord, is representation and period. AKN. Page number 32, mine, which is English translation copy, my lord. Regarding stoppage of establishment of dry wastage disposal unit. With reference to the aforesaid matter, the residents of the Giryapura village submitting this representation to esteemed officer, requesting not to construct a dry wastage disposal unit.
Heard learned advocate Mr. So and so for the petitioner and learned additional government advocate Ms. Neelofar Akbar appearing on behalf of the respondent state and its authorities upon service of copy of the petition in advance. Full stop. The only prayer this petition witnesses is to direct the respondents number 2, respondent 4, and number 6, who are
The deputy commissioner.
either you dictate or we dictate.
Sorry,
You want to dictate the order?
sorry,
Please sit down. Please sit down. The deputy commissioner, the principal secretary, and the chief executive officer, Jilla Panchayat respectively, to consider the representations dated 19/10/23, 18/8/23, and 7/12/22 of the petitioner. Petitioners. The petitioners, 5 in number, who are the residents of the village Giryapura, Kadur Taluka, Chikmagalur district. They have come with the case by filing this petition styled as public interest petition, public interest litigation, that they have submitted the aforesaid representations to the competent authorities, in which they have requested to stop the dry wastage disposal unit in the Giriapura, in the village. It is the case that as per the rules of the Jilla Panchayat, it is the case that the dry wastage disposal unit will lead to hazardous health problems and could not be permitted to be set up as per the rules. Full stop. It is stated that the villagers stay within 100 meters of the proposed site of the unit, and that there are schools also, and that the schools also are located. Full stop. It is the case and the grievance that the villagers, students and teaching staff as well as the public at large would receive adverse effect in terms of health and other issues if the dry wastage disposal unit is permitted to be set up. Full stop. The only prayer in the petition, as noted above, is to require the respondents to consider and decide the representation of petitioner. Full stop. Even otherwise, the subject matter to be looked into for their pros and cons is the domain of the executive authorities, the respondents here. Full stop. Court has no role to play in such matters. Full stop. There is no presumption that the authorities will not act in accordance with law and as per the rules. Paragraph. In the aforesaid view, this petition is not entertained. However, looking to the prayer, the respondents are directed to consider and decide the representations of the petitioners in relation to the grievance raised by them, as expeditiously as possible and preferably within a period of 8 weeks from today. Present petition is accordingly disposed of. Yes, next.
Pre-urgent, seal number 4, Mr. Nagaraj NR. I'm 4.
Petition, my lord.
Yesterday.
Yes.
Yesterday, lordship was pleased to hear me.
So are you inviting order or withdrawing?
One,
Are you inviting order or you want to withdraw? We are not with you. Yesterday it was heard. It was kept for orders since we wanted to confirm our application of mind, and that we have confirmed. What do you want?
no, your lordship permit me. I'll
Now
see.
there is no second round of argument. It is kept only for orders. It was argued. What do you want? Anything you want to add?
Nothing.
Any additional argument you want to advance?
No, only thing is, I would like to reiterate the orders of the full bench. That's all.
Which full bench?
Kerala,
Kerala.
Kerala.
Where is that?
Yesterday I submitted in respect of review order.
This one.
That's the latest available. This dated 26th May 2022. May I read? This is in regard to the payment. Can I proceed?
Lord Learned Advocate Mr. Nagaraj NR for the petitioner and Learned Additional Government Advocate Ms. Neelofer Akbar, appearing for the respondent state and its authorities upon service of copy of the petition in advance. Styled as not styled as, projected as public interest petition. What is prayed in this petition is to declare that the temples in the state of Karnataka are not public authorities, within the meaning of section 2 into bracket small h bracket O of the Right to Information Act 2005. In that light, it is further prayed to direct this number 2. As the Commissioner, Hindu Religious and Endowments Department to withdraw the notification Shibandi, SIBBANDI, Shibandi, dated 16/6/2007, along with the subsidiary notification Shibandi, dated 3/2/2007, and their connected amendments. Where is that notification page?
A and B.
Yeah, okay, 76, full stop.
Forty-two page number.
Listeners have stated that they are the Association of Priests, Agamikas, AGAMIKS, Narchaks, ARCHAKS, of different temples situated in the state, and that it is a registered association. It was submitted that it was stated that the applicants have no personal interest in bringing a challenge in this public interest petition paragraph. The grievance is addressed. Grievance is sought to be addressed in respect of notification dated 16/6/2007, bearing number Sibandi, individual staff, issued under the Right to Information Act by the state. With Right to Information Act. Whereby public information officers are sought to be appointed. Public information officers are appointed under section 5(1), 5 into bracket 1, 5 into bracket 2, and also under section 19 into bracket 1 of the Act. The temples are treated as public authorities under the Act. It is to be noted that only those temples who come under the purview of the Karnataka Hindu Religious and Endowment Institutions Notification 1997 are included under the notification. Case of the petitioners, paragraph. Inter alia is that certain persons who call themselves as whistleblowers harass the archakas and staff of temples, entered the notification whereby the public information and the aforesaid notification whereby public information officers are appointed in the temple, Pama would provide them a tool and the leverage to further harass on such ground, and further stating that the on such grounds and such grounds elaborate and on such grounds the petition is seeking the aforesaid prayer. Full stop. In support of the case and the plea, PLEA, learned advocate for the petitioners, rest into service. Several decisions. A decision of the Supreme Court in Sri Marthananda, MARTHANDA, Marthananda Verma, through legal aids, through legal representatives versus State of Kerala, 2021 1 SCC 225 big bracket, 2021 small bracket inside, was relied on, which was a decision which dealt with the subject of holding of office by the successive rulers of Shebait, SHEBAIT, and the issue whether they held it in personal capacity as manager in charge of the temple properties or as head of state. It was held that the Shebait ship did not lapse in care of the state by principle of ESCHEAT, eschat. Another decision of the full bench of the Kerala High Court in State of Kerala versus Vijesh Kumar and others, which was writ petition in the C number 20495 of 19, was relied on. He said in the said decision, group of petitions were dealt with. The point which was considered by the full bench was on the basis of the order of the reference in writ petition, and it was and writ petition, as to whether the GMDC, GDMC, and the commissioner had the authority under the Act to part with Devaswam funds to Chief Minister's Distress Relief Fund. The legality of certain administrative decisions on that score were called in question. Thus, the said decision of the Kerala High Court had a context of the entirely different facts, which stands true in their own facts. The decision of the Bombay High Court in Archbishop Patriarch of Goa versus State Information Commissioner was into bracket two into bracket big bracket then small bracket 2023 bracket over 6 AIR Bombay R 312 was in respect of whether a particular authority was a public authority within the meaning of the Right to Information Act, and order dated 16/12/14 in that regard was challenged. It was a case of specific instance to decide whether the body was public authority. The other decisions of Kerala High Court in AC Bannuni BHA, the NU, NNI versus Commissioner Hindu Religious and Charitable Endowments, as also of the Hyderabad High Court in G. Gajendranath Gaud, GOUD versus Government of Andhra Pradesh, which was writ petition number 21677 of 2007, and cognate petitions, were based on their own facts and would not help the public interest petitioner. Full stop. As noted above, the challenge is to the notification, whereby the as noted above, the grievance is about the notification issued by the authorities to treat the temples under Karnataka within the purview of Right to Information Act. Full stop. The class of temples, as already noticed, as reflected, the class of temples, as already noticed and reflected in the impugned notification, which come under the Karnataka Hindu Religious and Endowments Institutions Notifications 1997, are covered. Paragraph. A mere ground that not only that the subject matter cannot become a public interest petition, the ground that the so-called whistleblowers harass the acharaks of the temples, is too vague and nebulous to be too vague and too nebulous to accept the case of the petitioner against the notifications. Full stop. No case is made out to exercise the public interest jurisdiction. Full stop. The omnibus prayer cannot be granted. The petition is dismissed. However, it is observed that full stop. Whistleblowers वाला sentence आता है ना, acharaks, the grievance of the acharaks and pujaris is really misplaced when they apprehend that the whistleblowers harass them. Full stop. In any view, the information to be provided would be by the public information officer, and for that, acharaks could not have any objection. Full stop. Last line. The petition is therefore not entertainable, and the same is dismissed. Paragraph. While parting, it is our clarified that the dismissal of this petition will not close the doors for individual body to agitate their rights in an appropriate petition to contend that it does not fall within the ambit of public authority under the Right to Information Act.
Green bench matter.
Court, however, does not express any opinion on that score.
Still number 5, the Suraj Nayak.
My lords, the petitioner counsel is currently unwell, my lord. I'm praying for adjournment, my lord, in this matter.
You are not completely audible. What do you want?
My lords, the petitioner counsel is currently unwell, my lord. I'm seeking for an adjournment, my lords.
Unwell, all right. It will go to 27th of June.
Much obliged, my lord.
Number
As
6.
it was requested that the counsel for the petition is in indisposed health, and all to 27th June. Yes.
December 6, Mr. Ravindra Gajanand Pillai.
Please, my lords.
You are specializing in green bench.
Yes, my lord.
Matter. But not such. Yes, what is it about?
The other day matter was posted and my lords were pleased to post it today for hearing. Though I submitted that identical matter is posted on.
Yes, what is it?
The identical matter is posted on 11/7/23/24.
It's covered by the judgment. That is why it is posted today.
Justice Oaks judgment. Justice, the division been headed by Justice Oaks, as you say.
No,
Yes, my
your
lord.
lordship's order.
That is followed by our order. Let us see, where is that order? Yesterday
I'm
also
sorry.
you said that some similar matter is coming on 11.
Yes, my lord, because herein the matter was heard.
Today also you are saying similar matter is coming.
No,
on
no, I am ready for arguments today also, but I just only,
I'm sorry, this is not your lordship. Coordinate bench of this one.
I have already produced along with my.
Justice Oaks.
So this, I am here to go through, my lord. I am not aware of this judgment.
What do you want? We leave it to you. If you want to proceed, you are welcome.
Yes.
If you are not want to proceed, also welcome.
I am prepared to submit, my lords.
You are ready to submit?
Yes, my lords.
Yes. This is the. Yes. Yes.
So herein, my lords, the issue pertains to Rule 8A2,
Yes.
which came to be substituted effective from 12/8/2016 by way of a Gazette notification dated 17/3/2023, my lords.
It came into force with effect from?
Substituted, that means it has to take effect from the original date, that is 12/8/2016, my lords. By virtue of that substitution, Rule 8A4 came to be omitted. Rule 3, 4, and 5 came to be omitted. And whatever decisions the other side is going to rely on are of no assistance for the timing after the amendment, my lords. But now issue is herein, I had applied for the grant of a quarry lease way back in the year 2006, and I was granted a quarry lease valid for a period of 5 years, effective from 2006 to 2011. As per earlier or erstwhile Rule 21(2), I ought to have filed renewal application 90 days earlier to the expiry of the lease deed, which petitioner failed, my lords. That's why that issue remained there itself. Thereafter, being agreed by the order passed by the competent authority, revision was filed, and in 2017 that revision petition came to be disposed, stating the newly amended rule effective from 12/8/2016, my lords.
No, where is that revision? This is
Revision order. Annexure H at page number 95 in Canries and page number 97 at typed copy of that order or a translated copy of my lords at page number 97.
So your renewal application rejected.
Yes.
And what is the revision of?
The matter stood as that is 17/3/23.
Dismissed, these were dismissed.
Beg your pardon?
Revision was dismissed. Hereby dismisses the revision application number 224. Further,
What?
the competent authority is directly informed to take action in accordance with the provisions of the Karnataka Minor Mineral Concession Rules 94, amended notification 16, and dispose of the revision petition. So what does this mean that take action in accordance with Rule 16 rules?
It has to be put for auction. From 12/8/2016, all the mineral concessions shall be disposed of through auction only.
So neither Rule 8A2 introduced in 2016, nor the Rule 8A, which was again amended in 23, will come.
Yes, my lord.
It will not come to your help.
No.
Once there is no application pending. That's
Sorry,
the
my,
simple.
I may kindly be permitted.
You show us to be able to proceed further.
Yes, my lord.
That your application was alive and pending.
Yes, my lords. Because the law provides the third provision of Rule 8A2, the newly amended 8A2, second provision. I may kindly be permitted to read, my lords. Provided further that the quarry lease or license which are granted before 12/8/2016 and the period of such lease or license expired before commencement of these rules shall be considered for extension of period under the provisions of this rule. This is the explicit mandate given by the legislature, my lord.
What do you say about it?
This will not come into the aid of the petitioner because the application for renewal was rejected way back in the year 2014 itself. 23/7/2014. 23/7/2014.
That is admitted fact.
That's an admitted fact.
But
and this proviso says
Granted before
12/8/2016, and the period of such lease or license expired before the commencement of these rules means that is 17/3/2023, just prior to, in between this period.
What he's reading is what?
12/8/2016 to 17/3/2023.
So what the council, Mr. Narayan reads is the amendment of 23.
23.
But for better appreciation, I may kindly be permitted to read sub-rule 2, my lords, which is substituted rule. All the query leases or licenses, the starting word itself is all the query leases and licenses granted before the commencement of KMMC Amendment Rules 2016 shall be deemed to have been granted for a period of 50 years in respect of specified minor minerals and for a period of 30 years in respect of non-specified minor minerals from the date of its original grant, subject to the establishment of mineral availability and workability of quarry, and also subject to condition that all the terms and conditions of the lease or license have been
As my brother is rightly, we are discussing that there is nowhere in these provisions how to deal with the rejected application.
8A8 is clear. 8A8.
8A8.
8A8, sub-rule 8 of 8A. If the contention of the petitioner were to be accepted, then 8A8 become redundant. May I read? No?
Rejected.
Rejected.
Provisions of this rule notwithstanding any content shall not apply. So
Yes.
that
sorry, my lords, either let him submit at a stretch or I may kindly permit it, because now I just can't, because my flow
Sorry,
gets
for
little disturbed, my lords.
now don't break the thought of counsel. Yes.
So annexure D produced at page number 75.
But now eight crops sub.
Yes, yes, because now he was, I think a learned government advocate was referring about sub-rule 8.
If your argument is accepted in all applications.
Yes, my lords.
In indefinite will have to be.
It is not
considered
indefinite, my lords. Now the doors are closed.
All indefinite, all past applications. Rejected, not rejected, renewed, not renewed.
My respectful submission, my lords. Doors of Rule 21(2) came to be closed. No application can be received after 12/8/2016. Doors are closed. Now nobody can file a new application. What are applications which have been filed there prior?
Right. Right.
Yes.
It can go to like to any extent.
Yes, that is the legislative wisdom. As per Chevti Venkanna's case, my lords, it is very crystal clear. I have already produced. I may kindly be.
What is not intent cannot be a wisdom. It is
No,
not the legislative.
because I too was a little doubtful about the position of law, my lords. When I gone through Honorable Apex Court order, it was made very clear. I may kindly be permitted to read, my lords. Paragraph number 30, my lords. At internal page 299. Shall I read, my lords?
Yes.
From the aforesaid authorities, it is settled that there is a demarcation between the legislative and judicial functions predicated on the theory of separation of powers. The legislature has the power to enact laws, including the power to retrospectively amend laws and thereby remove causes of ineffectiveness or invalidity, full stop. When a law is enacted with retrospective effect, it is not considered as an encroachment upon the judicial powers when the legislature does not directly overrule or reverse a judicial dictum. The legislature cannot, by way of an enactment, declare a decision of the court as erroneous or nullity, but can amend the statute or provision so as to make it applicable to the past. The legislature has the power to rectify through an amendment a defect in law noticed in the enactment and even highlighted in the decision of the court. This plenary power to bring the statute in conformity with the legislative intent and correct the flaw pointed out by the court can have a curative and neutralizing effect. Important is I will be now reading my notes. When such a correction is made, The purpose behind the same is not to overrule the decision of the court or encroach upon the judicial turf, but simply enact a fresh law with retrospective effect to alter the foundation and meaning of the legislation and to remove the base on which the judgment is founded. This does not amount to statutory overruling by the legislature. In this manner, the earlier decision of the court becomes non-existent and unenforceable for interpretation of the new legislation. No doubt, the new legislation can be tested and challenged on its own merits and on the question whether the legislature possesses the competence to legislate on the subject matter in question, but not on the ground of overreach or colorable legislation. Herein, no doubt, my lords, till 17/3/2023, 3 or 4 decisions which the learned government advocate has relied upon were passed. All those decisions were based on erstwhile Rule 8A sub-rule 4, which came to be amended by the legislature effective from 17/3/2023. It is not at all in existence because therein the requirement of filing a renewal application 90 days earlier to the expiry of the lease was taken out. And there is no question of whether you have filed a renewal application, whether your renewal was granted or not. That is not for consideration. So by virtue of sweeping amendment carried out effective from 17/3/23, substituting the earlier rule effective from 12/8/2016, I am entitled for deemed extension for a period of 30 years from the date of original grant, my lords. And all those decisions which the other side is relying on, it is absolutely based on sub-rule 4 of Rule 8A, which is not at all there on records as on this date or after 17/3/2023. This position of law cannot be disputed, my lords. May I continue? So now herein, there are 3 facets to newly substituted Rule 8A2, my lords. One is the validity period of the leases granted earlier to 12/8/2016 in respect of specified minor minerals shall extend to 50 years. And 30 years in respect of non-specified minor minerals. That is the first paragraph of the rule says. The second one says about the newly reclassified minor minerals that is newly introduced effective from 10/2/2015 pursuant to Government of India notification. We are not aware whether that is a specified minor mineral or non-specified minor mineral, but it is called as reclassified minor mineral, for which no definition is available in KMMC rules. But insofar as specified minor mineral is concerned, it is defined. Similarly, non-specified minor mineral is also defined under the KMMC rules, my lords. Now, be that as it may, my lords. Now, coming to the next proviso, which I already submitted, still for the cost of the repetition, I may kindly be permitted to read. Provided further that the query leases or licenses which are granted before 12/2016, wherein I am eligible, and the period of such lease or license have expired before the commencement of these rules, that is 2023 rules. What is sought to be interpreted by the other side is not relevant. If you read that, expired before the commencement of these rules shall be considered for extension of period under the provisions of this rule. That this means this is newly substituted rule, effective from 12/08/2016. This is the legislative intent.
Yes, what?
May kindly be permitted. Herein, a notification which I have produced at page number 75, which categorically state is issued by Government of India, my lords. Some 31 minerals, minor minerals have been, major minerals have been reclassified as minor minerals. Whereas ordinary building stone and others, way back in 1994 itself, they have been notified.
How does it help you?
Yes, my lords. It will help to me that this is a class by itself, separate from or specified minor mineral and non-specified minor mineral. That's the reason rule 8 is not applicable. Sub-rule 8 is applicable only to reclassified minor minerals which have been reclassified pursuant to Government of India notification date 10/2/2015. So that's why rule 8, by any stretch of imagination, cannot be said that this is applicable to query leases granted to me in the year 2006 till 2011, my lords. So in my rejoinder, I made it explicitly clear, my lords, stating that what is the legislative intent and what is the present 2023 amendment. Even when it is made applicable to all expired leases, it cannot be said that sub-rule 8 will come in the way for granting me or deemed exchange benefits of deemed exchange.
Lord, my preliminary submission is that, Lord, the present petition is not maintainable for delay and latches. Last, may kindly see. The renewal application of the petitioner filed after lapse of 2 years, 2 months from the date of expiry, that is 24/3/2011. Date of expiry was 24/3/2011. They ought to have filed a renewal application 3 months prior to 24/3/2011. However, they have filed this application after lapse of 2 years, 2 months, which came to be rejected on 23/7/2014. 23/7/2014. This order came to be challenged before the revisional authority. On 13/10/2014. Which came to be rejected. The order of the competent authority was confirmed on 12/1/2017, 12th January 2017. The present petition is filed on 4/3/2024 after lapse of more than 7 years from the date of the order of the Joint Revisional Authority and almost 10 years from the date of the rejection of the renewal application by the competent authority. The petitioner files representation in the year 2023 in order to invoke a cause of action. He files a representation on 20th December 2023, for which reply was given by the competent authority on 27/12/2023, which is produced at Annexure A, which is under challenge now. This cannot be a cause of action for maintaining this petition, Lord, because way back in the year 2014, competent authority rejected the renewal application and revisional authority confirmed the same in the year 2017 itself. Therefore, my submission is there's no explanation offered by the petitioner for the long delay of 7 years in filing this petition.
That is, this, you're taking, not raising any ground on merit.
No, I'll come to the merits. This case is squarely covered by the judgment of this honorable court. In the case of PP Rajgopal versus State of Karnataka, which I have produced, dated 11th in WP number 46590 of 2019, dated 11th March 2022. The contention of the petitioner that this is not rendered in view of the new act which came into effect, amendment which came into effect from 17/3/2023 is incorrect, because this judgment is delivered on sub-rule 8 of Rule 8A, which is not amended by the virtue of the present amendment. The another contention that Rule 8A8 is not applicable to non-specified mineral is incorrect. This submission has been raised by the petitioners in various petitions and negated by this honorable court. 8A8 itself is very clear. It is evident from the plain reading of 8A8 that 8A8 is applicable to all category of minor minerals. I may be permitted to read 8A8. The provisions of this rule, notwithstanding anything contained therein, shall not apply to the quarrying lease. That is one category. Quarrying lease is granted. Sub-rule 8 of Rule 8A. Shall not apply to quarrying lease. That is the lease granted in the government land, or license that is in the private land, or mining lease. This is the third category. Mining lease of minerals now classified by the central government. That is
what is trying to.
Yes, yes. There are three categories. Therefore, all the categories are covered under 8A8.
So
Quarrying lease, license, and classified.
is it some relevance?
Because he wanted to distinguish therefore, the submission of other side, it is only applicable to the classified, notified minerals by 10/2/2015 by the central government is incorrect.
Why?
Because 8A8 covers all the category. Quarrying lease, license, or the mining lease of minerals now classified as minor minerals with a notification dated 10/2/2015. Granted before the date of commencement of Karnataka Minor Mineral Concession Amendment Rules 2016, for which renewal has been rejected. This is a case of rejection of renewal, or which has been determined or lapsed. Therefore, Lord, the provisions contained in 8A sub-rule 2 is not applicable for the categories for which renewal has been rejected or which has been determined or lapsed. Now, may I take your lordship to the judgment, Lord, which I have produced.
So this is which mineral?
So non-specified.
No.
It's an ordinary building stone which is classified as
Building stone.
non-building stone.
Non-specified.
So in the earlier,
There shall not be any confusion, Lord, because the other side is trying to confuse, stating that this is only applicable to the category of 88 is applicable to the category of the minerals which is notified in the notification 10 to 2015. No, it is not so. 88 is applicable for all the minor minerals. Wherever quarry lease is granted, license is granted, and those minerals which are notified under the notification dated 10 to 2015. For which renewal is rejected, lapsed or determined, the benefit of extension can't be given. Now may I take your lordship to the judgment?
anything? Now this judgment is clear once it is rejected.
Yes.
But my.
Now, the very question has been considered by the division bench.
Justice Avasti and Justice System.
Yes, yes. In para 3, para 3, bottom question, Lord. The short question which would arise for consideration is whether sub-rule 8 of Rule 8A of KMCR rules is applicable only to the minerals which have been reclassified from the major mineral to minor mineral with a notification issued by the Government of India bearing number so-and-so dated 10 to 2015, or would it apply to all applications which have been rejected prior to coming into force of amendment of KMCR in the year 2016 with effect from 12/8/2016. This question was raised by the coordinate bench, Lord, and in conclusion, para 4, Lord, in the instant case, it is not in dispute that the renewal application was filed by the petitioner on 13/7/2009, and the same was rejected on 19/3/2014, that is before the commencement, before the amendment came into force on 12/8/2016. Under these circumstances, in view of the aforesaid decision, in the case we are of the considered opinion that there is no merits. Here is also a case where renewal application was rejected in the year 2014. Therefore, this judgment is fairly applicable to the facts and circumstances.
My submission, my lords. Before going to other aspect of in reply, my lords, I may kindly be permitted to rule sub-rule 8, my lords. The provisions of this rule, comma, notwithstanding anything contained therein, comma, shall not apply to a quarry, lease or license or mining of a mineral now classified as minerals, wide notification of Government of India bearing number so and so, dated so and so, granted before the date of commencement of Karnataka Minor Mineral Concession Amendment Rules 2016, comma, for which renewal has been rejected, comma, or for which or which has been determined, comma, or lapsed. Only three things are mentioned herein. There is no such category. What learned friend has said that
You also rejected.
rejected what, my lord? The rejected is not the query lease. It's the query renewal application came to be rejected. That is not the issue here. Here they are speaking about the lease. My lease has not been rejected. My lease has not been determined. My lease has not been lapsed. My lease, after enjoying the full period of 5 years, I stopped querying. There is no question of rejection. What was rejected is only my renewal application. That is out of question for the time being, because it is deemed extension. As my lords very well know, in Nirmala Ben's case,
Renewal is rejected, therefore lease is determined.
no, there is no necessity of renewal, my lords, because rule 4 is omitted.
New minerals came to be notified at the time of amendment.
31 minerals.
So he is a we are dealing with building stone.
Delay doesn't arise, my lords. My cause of action arises only.
Building stone.
Building stone, a non-specified mineral.
So building stone is non-specified.
Yes.
So it was part of notification.
No, it is not.
It is 1994 notification.
It is not.
When the rules came into
by the virtue of 10/2/2015 notification, Lord, 31 major minerals are reclassified as minor minerals, specified minor minerals. That is not an issue in this case law. 10/2/2015 notification is not relevant for the purpose of this case, because we are dealing with building stone, which is non-specified mineral.
That's why that sub-rule 8 is not applicable.
What is this 10/2/15?
10 to
Earlier notification.
the notification of the central government classifying 31 minerals as specified minor minerals.
Specified ಅಂತ ಇಲ್ಲ ರೀ. Sorry, I beg to ನಾನು ನಿಮ್ಮ ಹತ್ರ ಮಾತ್ರ.
How many? 35?
31.
31, yes.
31.
Minor mineral.
Minor minerals. At page number
Specified
75,
minor.
my lords. I have produced the gazette
Specified
notification.
minor.
Specified minor.
Sorry, my lords, I am very sorry to say that there is no word used as specified. That's why I have produced the gazette notification. It is only minor minerals. We don't know whether it is
It
specified or
makes no
non-specified.
difference. It makes no difference.
Make any difference.
Yes, my lord, it does make, my lords. I will be submitting, my lords. In that, I was only referring to Rule 8. Rule 8, viewed from any angle, even in non-obstante clause is also taken. Excluding that rule, my lords, this is quarry lease, license, and mining leases of miners now classified as minor minerals. That is in a single line. There is no comma. Confusion is sought to be presented by the other side, not by me. It may be viewed once or twice. I may kindly be permitted to read, my lords. And the legislature in its wisdom has used comma in 2 or 3 places. But whereas in quarrying lease or license or mining leases, no comma is mentioned. That's why all the 3 are applicable only to minor minerals, which has been now reclassified by way of notification, Government of India notification of 2015, my lord. That is my humble submission. So that cannot be interpreted in the manner to say that it is either a specified minor mineral or otherwise. Where does those words find therein? Merely because inventing some new words and placing before the honorable court, my lords, I am very sorry to say. So that's one aspect of the case. And 3 other points were raised, and for that I would like to reply. That is delay and latches, which has been raised. But this amendment came into force only on 17/3/2023. Earlier thereto, I did not have the occasion to come before my lords. That is the starting point. So herein, my earlier renewal application was.
Yes, challenge divisional order. Divisional, yes, challenged. Not
Yes, I have.
He has challenged annexure A.
Revision order is not challenged.
The endorsement issued. The
Because
reply issued.
in 2017, I had no occasion to challenge, my lords. In that instant, now only after 2023, the legislative has given me an opportunity to.
We are asking the question to somebody else and
Please,
getting answer from somebody else. That course is not we are approving. Yes.
Annexure A is the reply issued to his report. Annexure A is the reply to his letter dated 2012-2023. He has neither challenged the rejection by the competent authority or the order of the revision law.
We wanted you wanted extension of co-release.
Beg your pardon?
You wanted thereby extension of co-release for 50 years.
Yes, 30 years, my lord. For
Sorry,
non-specified minute, it is 30 years.
30. For specified, it is 50.
As per 16.
23.
23. That is all. Anything more?
Yes, the only other 2 points which has been raised. The covered by judgment, my lords, all those judgments are based on main judgment, that is K. Ramaswamy, that judgment speaks otherwise. I have produced at page number, annexure at page number, annexure L at page number 117, and at the relevant page at 119, my lords, at paragraph number 15. In the bottom, my lords. At paragraph number 15, my lords, we answer the point raised by holding that the provisions of sub-rule 8 of rule 8A of K-means rules would be applicable to all minerals which have been classified as such in notification issued by Government of India bearing SO number so and so dated 10 to 15, and not only to minerals reclassified on that date. Explicitly made clear that sub-rule 8 is applicable to minerals reclassified in sub-rule 8. Because mine is not a reclassified minor mineral, mine is 1994 defined ordinary building stored, which is a non-specified minor mineral minor. And in addition, to that, if sub-rule 4, which came to be omitted in 2023 amendment, makes the position very clear, my lords. I may kindly be permitted to read, my lords. The period of all the leases or licenses of the non-specified minor mineral, except the mining leases of the mineral now classified as minor minerals, granted before the date of commencement of K-MIMS rules 2016, the validity of their leases or license are expired or about to be expired under sub-rule 2 shall be extended and be deemed to have been extended with effect from the date of expiry of the period of renewal last made up to a period ending on 31st March 2020 or till the completion of renewal period, if any, or a period of 20 years from the date of grant of such lease or license, whichever is later, subject to the condition that all the terms and conditions of the lease have been complied with, and also subject to the condition that renewal application for which for the expired leases had been made by the lessee within the time period required for filing such renewal applications. That is the qualification, my lords. In earlier law, up to 17/3/2023, I should have filed a renewal application within the prescribed period. That entire rule 4 has been taken away from the statute books. It is not finding a place in the present statute books, my lord. That's why renewal has been rejected, revision has been, they are all inconsequential, is my humble submission, my lord.
That's all. So for orders on 21st.
Please, my lords.
Next. Yes.
Seal number 8.
In this case, my lord, this case, the appellant company has engaged senior counsel, my lord, and company has engaged senior counsel, and today senior counsel for inconvenient, some personal inconvenience. Kindly have it next week or any other date, 25th or 26th, my lord.
There was urgency, my
In
lord.
July now. 16th
Because of the
July.
urgency, my lord.
My lord,
16th July.
interim
There is
order
some
may be
urgency, my
extended.
lord.
Interim order may be.
May I make one submission? This matter was listed last Friday. Because of the urgency, my lord, I requested the honorable court.
What is the matter?
Urgency is, my lord, what happened? About 82 employees, my lord, they are not even extended to certain monetary benefits. And they are being paid, my lord, less than what is their entitlement for the
Learned
last 30
counsel,
years.
It was stated that the learned counsel.
That is the
senior
urgency, my lord.
The appellant is in indisposed health. Time was paid for in their grounds, 10 to. Let
Some
it
short date, whatever date convenient.
22nd July. Interim order granted earlier shall continue to operate till the next date. Yes.
What?
Seal number 9. Maitri Krishnan.
Appear for the appellant in this matter, my lord. My lord, the impugned order is an interim order, but I beg 5 minutes indulgence of this court, my lord, to convince that the interim prayer, my lord, sought for is a prelude and it's a first step in the final prayer, and hence it's necessary to consider this writ appeal, my lord. My lord, the background of the case, my lord, is the petition. The appellant herein is a union of workers employed in Chinmaya Mission Hospital, my lord, in Bangalore. The background is that from 2011 onwards, the hospital repeatedly holds referendums to determine who is the majority union. And thereafter, I am.
Which order you are challenging? Page 42.
Please, my lord. I'm challenging the order, my lord,
Yes, my
which
lord,
vacates the interim order.
Yes,
Starts
page-
at page 42, my lord. To
So
speak,
we'll consider day after.
please, my lord.
Today is what? Today is Wednesday. Then 18th will consider.
Please, my lord.
Seal number 10.
You know, 10 appellants
Basuraj.
counseled by me. All indulgence I would like to see. In my prayer in the writ appeal, one more additional prayer is required to be added. It is omitted. Your Lordship may kindly have this matter next week. I will file an application adding the additional prayer.
My lord, nothing survives in this writ appeal. It's only an academic one. My lord, the order of the learned single judge has been complied with.
That's
Now
not
the
correct,
elections has been
I can explain to your
conducted on
Lordship.
21/1/2024. Lord, the board has been constituted on 31st January 2024. Office bearers have been elected on 8/2/2024. Nothing survives. My lord may see the grounds that they have urged for filing this writ appeal. My lord, page 14.
That precisely the reason, my lord, I made that
It's purely
submission.
academic.
An additional prayer is required to be added. I am the scribe of the writ appeal. I know what prayer I
LNM.
had to be added. Why the government advocate is intelligence, I don't know. The question which are raised is before this learned single judge. Can a dispute under section 70 of the Cooperative Societies Act could be extended to a process of electoral roll is concerned? We have argued that it is outside the purview of the dispute under section 70 because of the language employed under section 70 itself. Secondly, my lord,
Election have taken place.
elections have taken place, but larger interest is involved Several other legal questions have been decided by the learned single judge. That is the reason I raised that. Now I wanted to seek a prayer. Certain orders passed by the coordinate bench of this honorable court would not stand as a good law because of the later judgment and other things. That is the reason I seeking time, my lord.
This is writ appeal.
Yes, my lord.
Writ appeal.
How can you add a prayer at this stage?
Beg your lordship.
How can you add a
My
additional?
lord,
prayer?
now the learned single judge declared the law holding that election.
File a fresh petition. You can't add a
My
prayer.
lord, the findings and observations made by the learned single judge will come in the way.
We'll say a question is
My
open.
lord, he declared the law, my lord. Otherwise, your lordship
Say
set
the-
aside that order.
We will only say that this, whatever you are arguing is academic, therefore it is kept.
My lord, may I request your lordship that I will add that prayer. Give me 2 days' time. I will argue the matter. Take a decision. I will accept it, my lord. Absolutely no dispute at all.
24. 24.
Very well.
This is number 11, Mr. Vijay Kumar.
But the appellant was working as assistant executive engineer, non-graduate in KPTCL, Mala. Not a circular was issued that persons who acquire BE degree are permitted change of cadre, Mala, from assistant executive engineer, non-graduate to graduate, Mala. But the appellant passed a BE degree in January 2012, Mala, and submitted a representation in terms of the circular. That circular was issued on 22/11/2007, Mala. He submitted a representation on 24/8/2012. On the ground that a departmental inquiry was initiated against him, my lord, his claim for change of cadre was postponed. And subsequently, my lord, on 29/8/2015, he was permitted prospectively, my lord, change of cadre. My lord, in the seniority list, my lord, he was assigned the date of eligibility from the date the order of change of cadre was permitted. My lord, I challenge the ranking assigned and the impugned order, my lord, by which I was prospectively extended the benefit of change of cadre. Though there was no pleadings regarding delay in latches, my lord, the learned single judge proceeded to dismiss the writ petition on the ground of delay in latches. It was also observed, my lord, that pendency of a departmental inquiry would not come in the way of taking a decision on change of cadre in terms of the circular issued. The circular is at, my lord, page 92. The two conditions that are prescribed is, my lord, that one should have acquired the BE degree and should have made a written request. I had made a written request in 2012 itself, my lord. Whereas my juniors who were, my lord, also passed the BE degree.
Where is 27 endorsement dated 27/8/2021?
Page 302, my lord.
300.
But translated copy I have produced at page 303.
So your objections are not accepted.
Not accepted.
Is your challenge?
This was challenged along with the, my lord, the order by which I was given,
And a single judge has said what about this?
my lord, the last single judge, my lord, proceeds solely on the ground that there is delay in approaching the,
7 years.
yes, my lord. But that cannot be, my lord, for the reason, for the first time, my lord, the seniority list was issued in 2021. Secondly, my lord, in 2021 pursuant to BK Pavitra judgment. My lord, secondly, my lord, I had made representations in 2018 and 2020, and in fact in 2014 also, my lord. My lord, the objection take.
Please return a one. 23rd July.
My lord, I take notice for respondent number 1.
Learned additional government head of local Akbar accepts notice on behalf of respondent 1.
Obliged.
Number 12. Anand Reddy.
Where respondent not in this case.
Your Lordship, appearing for the appellants in the matter CBSE. A writ petition was filed previously by now the current respondents, BGS Educational Trust, where the learned judge had ordered that CBSE be directed to reconsider the application for affiliation. Second part to this is the learned judge had allowed students to continue education in Standard 9 and upload their student data onto the CBSE portal. Now, the learned judge said that there is no material violation and could be cured through collected fine. Your Lordship, I would like to point out that the affiliation bylaws does not allow CBSE board to present students from unaffiliated schools to be present in the board exam. Sir, the CBSE has honored the previous interim order and has considered BGS Educational Trust's application, reconsidered it, but that application was rejected on 2 parts. One, the school was not surrounded by boundary walls on all 4 sides as prescribed for bylaws. And second, the land on which the building is located is on disputed land. And therefore, and also recently a demolition order dated 11th January of this year has been issued by BBMP against the school. Your Lordship, we would like this matter to be heard on a further date. And please, if you could, may this honorable court condone the delay of 27 days in the interest of justice.
Delay is the delay to be condoned.
27
Third
days delay
learned
is
counsel
there.
for respective parties. This appeal is delayed by delay of 27 days. Full stop. The delay to the extent of 7 days, 27 days has been explained properly. The supporting affidavit, sufficient cause is made out. Delay is condoned.
I make one submission.
Writ appeal will be listed for hearing on
I make one submission, Lord. This order,
26th of June.
Lord, this impugned order has been implemented. In the sense, again, my Lord, they have rejected. That, my Lord, I have again challenged in the writ petition. The impugned order, what my learned friend is challenging in this
What is
petition.
the impugned order? What is
The
impugned?
impugned order for reconsideration of my application for affiliation.
What was your application?
For grant of affiliation for CBSE, my Lord, CBSE course.
So who are you?
I am the institution, my Lord. Earlier it was rejected. I filed a writ petition. This honorable court, my Lord, has directed.
Your CBSE?
Yes, yes. CBSE is, my Lord, the appellant herein now.
Who are you here?
I am the institution, my Lord, which has applied, made an application seeking affiliation, my Lord, by CBSE to run the institution. So now what happened, pursuant to this order, impugned order, they have again reconsidered, they have rejected again. I have filed, my Lord, challenge again, my Lord, in the writ petition. It may not survive. That's what my submission.
Your Lordship, there are.
Reconsidered, rejected.
I got a copy of the order.
Yes,
also,
Your
my Lord, which
Lordship,
is-
CBSE has honored the interim order and had reconsidered the application.
Then this will not survive. You very good that you honored.
Sir, Your Lordship, but their application was rejected again. due to the fact that the school is not surrounded by concrete walls on all four sides, and it's on disputed land and territory. And right now, the school.
That is not the subject matter of this. Is it a subject matter of this?
Yes, Your Lordship, because the bylaws, I can submit it in the next hearing date. The bylaws prescribed, they have violated a number of bylaws. For example, the fire safety has not been complied with. Building safety certificate has also is not in the.
Will not serve.
Your Lordship, 27 students have been currently enrolled in Standard 9 who are not affiliated with CBSE, and their the CBSE bylaws.
Keep it tomorrow.
Your Lordship?
We'll keep it tomorrow.
Your Lordship.
We'll keep it tomorrow.
Okay.
You will get 24 hours.
Okay.
To read.
Okay.
And understand.
Okay.
Why this should not survive. Tomorrow at 2:30.
Much obliged, Your Lordship.
Just go through it, will not survive. We'll keep everything open if anything hurts you on merits, right? Tomorrow at 2:30.
Yes. Complaints in contempt matter, seal number 13.
My lords, I appear for request in this case. I'm filing a memo, my lords, for production of document. My lords.
Yes. What is it?
My lords, in writ petition. My lords, in writ petition number 11651 of 2024, the members of the association who are also the occupants of the shops in the upper basement of block 1 have undertaken to vacate the premises within 15 days, my lords. So 2 weeks time may be given to file compliance affidavit, my lords. The occupants have undertaken to vacate the premises of block 1, my lords, upper basement.
When it will be done?
Within 15 days, my lords.
15 days.
Yes, my lords.
So file your counter, file your statement.
After they vacate the premises, we'll file a compliance affidavit, my lords.
It is filed?
No, my lords, you have to file. So 2 weeks time may be given.
So whatever you need, how much time to vacate the?
15 days, my lord. They have undertaken before the single.
State that in affidavit, in your statement of objection.
We'll be filing our affidavit.
Learned counsel, Mr.
CH-1 for such person.
So for.
Your Lordship, kindly see the order of 16th April.
BBMP, Brahad Bangalore Mahanagar Palika stated that the directions complied with directions issued by learned single judge in
writ petition number 11651 of
February 2020, which would include the vacating of the shops by the occupants and clearing the parking place.
Yes, ma'am.
Comma shall be complied with within 15 days.
Yes, ma'am.
Full stop. He states that necessary compliance affidavit stating on oath as above will be filed within 1 week.
2 weeks, ma'am. 2 weeks.
No, you say 2 weeks will comply with. So you file affidavit that within 2 weeks will comply with.
Please, my lords.
Such affidavit may be filed on or before 25th of June to be listed on 26th June. So you file an affidavit on 25th of June, that within 2 weeks it will comply. Yes. That is right?
This order of the learned
This
single.
is more than fair. We are not expecting him to get the shops vacated within 15 days. But he is, yourself go to vacate. You yourself will go to get it vacated.
No, my lord, there's a single judge on.
Seal number 14. Pradeep Nayak.
My lord, I appear for respondent number 4.
Yes. This is a
Yeah. But we will cross dispensation.
Pass or will not? What is it about?
Lord, an application has been, IA number 1 of 24 has been filed by my lord, the respond number 5, BMRCL, seeking permission of this honorable court to my lord, allow them to my lord, to implement the project, my lord, in terms of my lord, the OM issued by the tree officer under the Karnataka preservation of tree, my lord, to cut my lord and translocate and my lord,
free, my lord, to carry out the metro project. BMRCL.
My lords, I have some submissions. I submit that Passover may not be necessary. I'm not opposing his IA. This petition was filed in relation to the Preservation of Trees Act, under which certain guidelines have been set out legislatively. There are two IAs which are for consideration before your lordships, IA 1 and IA 2 of 2024. IA 1 was filed by BMRCL, IA 2 was filed by me. Now, over the course of the last 5 years, this honorable court has issued a series of directions and a process by which any trees that are to be felled in relation to these projects, a detailed process has been set out. An expert committee has been appointed by this honorable court to look into whether or not each tree look into each tree and see whether or not it should be felled or if it should be translocated. The IA that they have filed today, my lords, I am submitting a memo. The petitioner submits that this is entirely in accordance with the directions that have been issued by this honorable court. We are therefore not opposing this IA. Now, what has transpired as a result of the orders that have been passed?
Who is some counsel is the town? You are supported by some town. Who is it to argue? You have to argue.
Lord, for them,
my application.
We're
going to argue this. You're
Lord,
ready?
if he's saying I have no objections to his IA, my lords. There will not be an
Which IA? IA number 1.
IA number 1.
Filed by my lord BMRCL on 3rd June.
Because they have produced the tree expert committee's report.
It should be separated. I already instructed. IA should be separated. Order sheet should be separated. It is not possible to find out.
May I be permitted to hand over my memo, my lords?
IA 1 of 24, my lord. Page number 9, my lord. Annexure R5 ADK. So for this, why do you want to file IA?
The background is this, Manas. The Honorable Court had set out this detailed manner in which it is to be carried out. This Honorable Court had found on multiple occasions that the BMRCL has not followed the process set out by this Honorable Court, and therefore directed, specifically so far as BMRCL is concerned, if they want to fell any trees, they must file an IA before this Honorable Court, and only then the trees can be felled. In fact, I have submitted, if time permits.
Grant this IA and dispose the matter some other.
That one IA may be disposed of. There is a series of IAs that are still pending consideration. And in fact, there are some constitutional challenges also that have been mounted to, which have not been heard. IA number 2 that I have filed, quite in contrast to the BMRCL's conduct, the BBMP has issued an official memorandum where they want to fell 800 trees. On 29th of May, they have issued it. That is in complete contravention of the orders of this Honorable Court. No expert committee report is produced. None of the factors that are to be considered have been considered at all. I filed that IA day before yesterday, and I have served them on the 10th. In fact, I had mentioned it before. My colleague had mentioned it before this Honorable Court yesterday, and your lordships had directed that IA be placed before the court on 18th for consideration. I have served the BBMP in the meanwhile. They may be directed not to fell these 800 trees until your lordships have considered it on the IA number 2. It's before your lordship. It's at serial number 26.
Lord, it's not against my lord.
It's not against BMRCL. It is only BBMP.
I appear for BBMP, seeking short accommodation to file objections. My lords.
Being held by BMRT.
No, that is by an organization called K-RIDE for the KRIDE for planting for a road. And I have set out in my IA the details as to why.
Pradeep Nayak.
Please, Manoj. As I have also submitted a summary of all of the orders that have been passed by this honorable court and a convenience compilation on exactly what the process is and how it should be. If on any given day I may be permitted to take your lordship, it will not take more than 15-20 minutes. Just to give the background of how many, in fact, by a virtue of these orders, a large number of trees have been saved in Bangalore over the last 5 years. This honorable court found that 98% of these applications were being allowed without any consideration at all, 98.5%. And Bangalore has lost 78% of its tree coverage in the last 30 years. We have produced all of these studies. This honorable court found that the act has not been complied with at all. And it has taken multiple continuing mandamus orders from this honorable court before the act has been partially complied with today. There are still compliances which I have filed IAs for.
You can take up this main petition as well as the both.
Lord, so far as IA number 1 is
Both
concerned,
IAs
Lord, this,
on-
Lord,
No,
there is a
not
great
for,
urgency, Lord, in the
Kindly listen, 26th.
Manoj?
26th will take.
Could it be the week after, Manoj?
Week
that-
after.
The first week of July?
My Lord, all the, my Lord, the procedure, my Lord, has been, my Lord, contemplated.
Week after
First week of July.
8th of July.
Please, Manoj. Because until then, the KRIDE should not fell the 800 trees,
We
Manoj.
are not passing any order, not modifying any order.
Manoj, they have issued the OM. Before the 13th, they will start felling the trees.
It is subject of your IA.
Please, Manoj. This honorable court had passed an order saying, if I file an IA within 15 days, that they should not fell the trees for 15 days so that I can approach this
We
honorable
want
court.
to fell the trees. For what purpose?
Lord, for Lord, IA number 1 is concerned, my Lord, for the project of metro, my Lord, construction of metro, my Lord.
That can wait.
Lord,
IA number 2, the OM that I have produced, they
IA number
themselves
2 is
say within
concerned,
15 days, they'll start felling the trees.
And this main petition is for precisely for that purpose.
Please, Manoj.
Against felling of trees.
Please, Manoj. And for compensatory afforestation, the act itself has been amended. We have challenged some of those amendments because it makes the.
This is one very strict.
IA number 2 was filed on 10th of June, Manoj.
10th of June.
This was issued on 29th of May. And on page 23, your lordships will see that it says this order will come into effect after 15 days from uploading the order on the official website of BBMP. That expires on Sunday, Manoj. On the 13th, sorry.
So this is metro rail project.
This is not metro, Manoj. Metro is only IA1. This is for a road project.
IA number 1.
This
IA
IA2 is in relation to a road project. Manoj.
Road project.
Please.
IA2.
Please, Manoj.
Which road?
As this is, your lordships would see.
Inside the city or outside?
It's called, it's Benninghalli railway station to Chikkabanavar railway station.
So it is within the city.
Please, Manoj.
Within the
This entire petition is for Bangalore city alone.
So why they are cutting? They widening the road?
Please, Manoj. They're widening the roads. No reasons are given. The orders of this honorable court are not complied with. The expert committee report is not placed.
Going to, are they in the process of felling?
Your lordships will see page 23. They say it will take effect within 15 days, starting 29th May.
To file a reply to this.
Yes, my lords.
To this IA2.
Yes, my lords.
You want to file or don't want to file?
We want to file, my lords.
Then don't cut till you file the reply.
Pardon me?
Till you file the reply, we will not permit you to cut in it.
Please, my
Full stop. IA2. Learned advocate Mr. So and so for
BBMP, my lords. Respond number 4.
Bangalore Brahad Mugan Mahanagarpalika.
Yes, my lords.
Prays for time, stating that he wants to file reply to this interim application. Full stop. The prayer in the application is against the felling of trees by the BBMP, which is stated to be for the purpose of widening a road. Full stop. Since the counsel for the BBMP is asking for time, some time is granted till 8th of July, before which date the
IA number 1 may be considered, my lord.
reply shall be filed to the present interim application. In the facts and circumstances case, there shall be no felling of trees. At which place?
Your lordship may refer to the official memorandum dated 29th of May in furtherance of the official memorandum, because that it is over a stretch of road.
No felling of trees in the area which is subject matter of IA.
Please.
IA number.
Till 10th of, we are in July 8th, till 12th of July.
Lord,
Deeply obliged.
Matter will come upon 8th. Interim order is operative till 12th of July.
Lord, insofar as IA number 1 is concerned, my lord, yes, no objection, my lord. There's an extreme urgency, my lord. Every day, my lord, the BMRC are going to lose, my lord, public money.
IA number 1 is only 6 trees they are felling.
One can be granted.
It may be granted, my lords.
It is granted.
Please. Permission.
Broadly, no objection.
I no objections. In fact, I've prepared a memorandum that I may submit to court on paper, just to say on record that I'm not objecting.
Lord, formal order has to be passed, my lord, by the Honorable Court, my lord. Until unless, my lord, that order is passed, we cannot.
Before we proceed with the main petition, Mr. Counsel, we would need the chronology of orders.
I will do. In fact, I have already prepared it. It is before your lordship. I've got a summary of all of the orders. I've made a convenience compilation. Before the 8th, my lords, I will sit with the with the court officers. I'll ensure that all of those papers are
Just to
pulled out.
decide whether these proceedings are to be continued
I
or
appreciate
to be
it.
disposed
I
of by
appreciate
some guidelines.
I appreciate it.
IA number 1.
And if you permitted.
Pending since 18.
Please.
So you assist that this is a real public cause, cutting of trees.
Lord, the Honorable Court, my lord, by order dated, my lord, 3/9/2020, my lord, constituted expert committee. Thereafter, my lord, on 17/2/2021, my lord, that committee, my lord, reconstituted. My lord, the committee has, my lord, formulated, my lord, certain procedure to be followed, my lord, before felling of the tree. We have, my lord, complied with all the, my lord, the procedures adopted, my lord, guidelines issued by, my lord, the GKVK.
No Kannada speaking netizen would like to cut a tree. So also I, even though I am not speaking Kannada. So we'll look into it.
I'll take your lordships through the detail. Deeply obliged.
Why should you unnecessarily cut the trees?
Lord,
Unless it is extremely necessary.
my lord, the metro, my lord, project is, my lord, very important.
we'll-
My
we'll
lord,
find out.
reduces, my lord, the pollution, my lord.
Modulate the relief in light of the
Lord.
earlier orders.
This IA only, my lord, 6 trees, my lord, to be translocated, my lord. We're translocating it to one area to, my lord, another, my lord, nearby, my lord, place.
Road widening.
This is for the metro, my lords.
This is for metro, my lord.
One subject is metro.
Please, my lords.
So there we are granting on your condition, whatever
Please.
you state.
Please, my lord, in accordance with that. Deeply obliged.
December 15.
I pay for the petitioner 15.2.
Number 15.
Not
Therefore.
on and. Not 15.2 may be taken up, Lord, that if that is decided, the other matter will automatically. But I am seeking recalling of the order dated 20th April 2017. Petitioner is a company, my lord. Page 19, your lordship can have a look at.
It is for refund.
My lord, refund only for interest portion.
What is what?
In fact, my lord, there was a,
Refund for what?
my lord, some investors, they have participated in an auction process through the company. My lord, the EMD was forfeited. Thereafter, they approached this, company approached this honorable court, and a direction was given to refund the EMD as well as on that interest. My lord, Annexure B is the order, my lord, your lordship, kindly.
Some part of the amount is repaid on.
Yes, my lord, my principal amount is repaid, only interest portion was there.
Out of interest, no part is.
My lord, interest is not paid. Now this writ petition, my lord, what my lord has filed is to review the earlier order passed, my lord, in the writ petition.
Let us see.
Such a petition is not maintainable.
Let us see earlier.
The earlier order itself is at page 19.
19.
19. This, now he wants to review this order by way of a separate writ petition. This is an order for refund of the earnest money deposit.
This 3 crore is the principal amount.
Principal amount that has been paid subsequent to
Deposit.
paid to
Deposit,
us.
and it is received by the company and paid to him.
Paid. It is already paid. This was the direction within 8 weeks in earlier petition.
Yes.
By issuing the account paying check by transferring amount.
This has been paid and we have received. My lord, in this writ
Now
petition,
in that petition, you did not make the prayer for interest.
It was made.
it was made.
No. In that earlier petition,
Yes, ma'am.
there was no prayer on your part to pay the interest.
There was a prayer.
There was a prayer,
There is
My lord, page 39.
the direction,
page 29.
39.
39.
Let us see. Where is that?
Lord, para 27, my lord, up to that, in the circumstances, the writ petition is allowed, the respondent shall refund the amount with interest at the rate.
Prayer, you are saying prayer was.
Prayer in the writ petition.
Lord, prayer is not extracted here, but para 39, the direction was to pay interest.
So prayer was there, we take it.
Yes. Yes.
Prayer was there and not granted.
It was
No,
granted.
it was granted.
No, the interest part.
Interest part also was
Granted.
granted.
Where you are showing.
By 39 itself.
You are
In the
showing pay-
circumstances, writ petition is allowed.
Yes.
The respondent shall refund the amount with interest at 12% per annum from the date of deposit till the date of payment. This is the direction.
Where you are reading?
Page 39, my lord, of the writ petition paper book.
I think
Internal page
15.2.
21. 1 minute. Lordship got it, my lord.
So this page 39 is in earlier petition.
Earlier petition, this was granted. Subsequent to this, principal amount was paid. My lord, in this writ petition, I represented. There is a direction and we received the amount. Now 12% interest had not been reimbursed by the state. Therefore, my lord, we filed another writ petition that this 12% interest is not paid. That writ petition came to be allowed. And the state has
That is page 19.
no, that is not paid.
Yes,
This is the
18.
original petition. The subsequent writ petition, my lord, where 12% interest was directed to be granted is in writ petition number 8533 of 2017. That is at page 15 to 18.
18. Correct.
Your lordship got page 18, my lord?
Yes. So what is the difference?
May narrate.
Now he wants review of this order in a separate writ petition.
Correct, we understand. But then we are not able to, at least I am not able to understand the connection between page 39 order and page 18 order.
Lord, may narrate the facts.
Right.
Page 18 order, my lord, is the sum of the calculated amount of 3 crore 4 lakhs agreed to be paid.
Yes.
This is the interest amount. This your lordship finds it at page 70.
This is interest amount.
This is the interest amount. This interest amount had not been paid, though the principal amount had been paid. Therefore, I filed this writ petition, my lord, in 8533. This was allowed.
Where is that?
That is at page 15 to 18. That is the order of this honorable court.
15 to 18.
Yes. Page
correct.
15, my lord.
Correct.
This is the order. Now, this order is, my lord, subsequent to this order, my lord, now the state has filed a review petition seeking review of this order, and the petitioner has filed a review petition seeking the review of the original order.
Original order.
Original order. The part of the order is complied with. Now, there was a direction by your lordship to deposit this amount because state directed to release this payment, and state released this payment of whatever the interest amount that had been this thing.
Your prayer in this petition would depend upon the outcome of the review.
Outcome of the
review.
Okay. Now, in this review, the state has already passed the direction to pay this amount first, and the state has deposited the amount in this honorable.
Interest.
Yes.
Interest amount.
Then what remains?
Nothing remains. According to me, nothing remains, my lord.
What remains?
Your lordship may kindly see the order passed by this honorable court in the writ petition. That order was passed, my lord, in the review petition filed by the state. This order is dated 19/8/2021, if your lordship gets this order. The state came forward and 19/8/2021 order, my lord. And now this amount is lying in the registry of this court. Nothing remains, according to me, my lord, in this petition or in the review petition filed by the state.
So this is passed in this very proceeding.
This very proceeding.
May make one submission. Admittedly, my lord, the third respondent who pooled this amount and participated in action, and we have also authorized him to collect the money. Kindly have a look at page 40, because I cannot suppress this. When we have given authorization, my lord, some of the people who has invested with him came and lodged a complaint with the company. At that stage, we have filed our objection, and this writ petition was filed. Now, my lord, they have settled their issue. They have filed a compromise petition before this honorable court in the first writ petition. Let there not be any liability on the company. That is only my interest in this.
I have no objection, my lord.
Let them file an affidavit to the court that there will be any claim against the company, they will take care of that. I will,
Which liability now?
Lord,
But is it within the purview of this then?
that is the only issue.
There is no issue here. It may be an only issue.
I don't know, my lord, how this petition, my lord, came to be filed. My lord, a writ order passed under 226 cannot be a subject matter of the review petition in another petition. That substance of the main
And the amount is deposited.
to be released to
File
us.
a review or appeal. I was not a party in that.
Us. Because that earlier writ petition, 8533 is by the respondent hearing.
May I submit, my lord? The first petition, I am appealing for the petitioner. The fourth respondent therein has received money from me because it is for iron ore, it required crores of rupees. For investment, he received from me, my lord, and I gave it to the company that is the respondent. That is the first order that is was in favor of the company, and the subsequent second petition, the authorized representative in the individual capacity, he filed the writ petition, and this honorable court directed that the payment to go. I being the investor, being scared that my money may go into the hands of the third party, I may not get, I filed the writ petition saying he filed frauds. In the first petition is not party. In the subsequent petition in individual capacity he filed. So I am here before court seeking let the money be refunded to me through the court which is deposit. That is the interest portion. Subsequently, now the fourth respondent agreed and he said that he will disperse my money and he filed the compromise petition on 10/3/2022. My lords may kindly regard the compromise petition filed between the parties and my petition may be disposed.
Where is the compromise? Am I a party? What happened to auction? Auction took place.
Auction.
Auction never.
MD
took
was
place.
forfeited.
Auction took place.
Auction 25% was sought to be forfeited. Therefore, we filed a writ petition that this because the forfeiture was for
They had financed the auction.
I had financed.
He has financed me, company.
Company, it was in the name of the company, but I had financed the auction. I represented the company, and that is how the whole thing, my lord.
You are Praveen Kumar.
I'm a teacher. I am the person who filed the writ petition.
Satyaprakash.
Both the writ petition. One in the name of the company, one in my individual capacity.
What is over you? Praveen Kumar? No.
I am appearing for Praveen Kumar.
You are for- So it is your petition.
I have not come before court. Now, my lord, because of their internal disputes, my lord, they are raising so many this thing, and the writ petition itself is not maintainable, is what my submission is. I don't know how this has come up.
We have given the authorization.
The last may kindly take my RP review petition, page number 5.
Page number 5. Yes.
Page number.
Right, summary. Narrated summary from page number 4. In 2008, a notification for auction of confiscated iron ore was issued, which iron ore was within the jurisdiction of Deputy Director of Mines, Department of Mines and Geology Hospital. The successful bidder was one Mrs. Chitraput Steel and Power Private Limited. That is the petitioner in one of the case. The government had forfeited earnest money, AMD, of the said company on its failing to deposit the balance bid amount. The company challenged the forfeiture of EMD in WP number 11/3/21 of 2011, and the Honorable Court directed that the amount to be refunded with interest 12% per annum from the date of deposit till the date of payment, and that the refund shall be within a period of 6 months. The company was represented by Sri T.G. Satya Prakash, the respondent herein. One of
That
the
is
respondents,
myself, my lord.
represented by my learned friend. Thereafter, T.G. Satya Prakash filed writ petition 8533 of 2017, seeking that payment as directed in WP number 11321 of 2011 be made to him. He was representing the company at that point of time. The government advocate on instruction submitted that the authorities had agreed to pay certain amount as directed. Later, it was noticed that the order in writ petition number 11321 of 2011 was to refund the money to the company, of which the respondent herein was merely an authorized representative, that is Satya Prakash. Further, when the order in writ petition number 8533 of 2007 was about to be complied within in pursuance of the undertaking given before the contempt court in contempt number so and so, and check to make payment was ready. A letter dated 19 June 2019 by the company represented by one of the directors, which was the petitioner in WP number 11321 of 2011, addressed to the second petitioner number 2, wherein herein was received claiming that the respondent herein is not entitled to receive the money, and the authorization to him cancelled in the year 2016.
Who is representing company today?
Satya Prakash.
You. And your season, there is no
authorization was taken.
Your petition is not pending, any petition.
Any petition.
But then it appears that the money is to go to the company.
No, the order in writ petition is money is to come to me.
So that is what we are saying. Money should come to you.
Yes.
But then in their petition, how can
No,
you-
subsequently, my lord, there is a compromise petition entered into by all the investors. That is in writ petition number
Nothing
3.
survives, Mister. Why we are debating all this?
I don't know, my lord. This
No.
may not lie within the purview of the petition. Whatever the internal dispute, they will have to agitate if they have any subsequent right flowing.
Your petition is 36679.
27261.
My petition, 36679 is.
So it doesn't survive.
It will not.
Here, the compromise is failed there. My lord may kindly take note of, because here. the
You
amount is-
are not entitled to any money.
I have paid the money to the respondent.
You settle
That
with
is
the-
their internal dispute.
Settle
No,
with
he
the
has agreed,
settle-
my lord. He has agreed to pay the amount. He
Settle-
has signed the compromise.
No, my lord, that is between Satya Prakash and Praveen. No, company is not a party in that. It can be decided in terms of the compromise petition among themselves.
Paid, my lord. In terms of petition, because 2 crore 74 lakhs, by selling it, mobiles, immobiles, I paid at the time of EMD. Because I may get something more. Now I lost everything. I am virtually suffering, my lord. And he agreed to pay the amount. My lord may kindly take
No,
note
no,
of.
that,
Very good.
there cannot be any dispute among them.
Very
They have filed a compromise.
Why should we?
They have paid before, my lord.
Yeah, they in the compromise, my lord.
Where is compromise?
Compromise petition is, my lord, in writ petition number 36679 of 2018. This was 10-3, my lord, it appears to have been filed, 10-3-2022.
This is the most complex matter I have come across since coming here. Where there is nothing as such, but still you are arguing.
My lord, we are extremely sorry, my lord.
If you have entered in-
Right then, because of, my lord, certain internal disputes, my lord,
Then if settlement is arrived at, you act according to settlement.
My lord, the thing is, company has not arrived with the settlement signature. It is between the
Company
two
is
private
nowhere, my lord,
individuals.
today.
My petition, I will make my submission very clear, my lord. The thing was, it is admitted fact that money belongs to Satya Prakash.
If my brother is not clear, how can I be clear? We both are sailing in same boat. because you are the.
May I clarify the things, my lord?
So this is memorandum of compromise.
Please, my lord. No,
It is acted upon or not?
please, my lord.
To be acted upon, my lord, money has to be received. We have filed the compromise petition. The money is lying in the deposit of this honorable court
As per this order.
as per this order.
The proportion mentioned in page 3 of the compromise petition.
Where is the signature of Satya Prakash?
Can we not dispose of the proceedings by referring to this compromise?
My lord, where company is not,
Of compromise and directing. the
company is
parties-
not a signatory in that.
Directing the parties to act in accordance with this. And taking note of the fact that as per the order, amount is deposited.
My lord, may I make one submission? I am representing company. This, my lord, there is no dispute that money belongs to Satya Prakash. And company has authorized him to collect. Because I have produced both authorization as well as it is an admitted fact that money is deposited by Satya Prakash at the time of auction. My lord, only dispute was some people have approached the company. I have produced the records saying that we have invested money because this, including Praveen, who is in the first writ petition. At that stage, I filed this writ petition. Now, my lord, my interest is to protect the company's interest. Let the Satya Prakash file an affidavit before the court that he will indemnify the company. If any claim against the company, then my lord, your lordship may take a decision because already there are 2 orders. I cannot go beyond that.
It is not
Lord,
only.
And I have given authorization, my lord. I cannot go beyond that. also.
Lord, may I submit?
I have given authorization. Page 40 is the authorization.
My lord, they,
Sir, our area of traveling only is this much. That somebody financed the auction,
Yes, ma'am.
then it was sought to be forfeited. Therefore, petition was filed. It was refunded. Then again, the interest was claimed and petition was filed.
Yes.
That was also granted by order. Pursuant to order, the interest is deposited.
Yes.
Now, whatever interest say you have to settle, it is a matter of settlement. We are not coming into it.
that's it.
That's the thing.
My submission is, my lord, in view of the withdrawal of the authorization by the company, which was granted in respect of Satya Prakash. Lord, the money directed to be paid to Satya Prakash, Lord, is doubtful because we have to pay. The money is deposited by the company, though it was represented by Satya Prakash at that point of time. The government interest to that extent has to be protected.
We'll go through before passing the order.
Yes, ma'am.
And so that the things. But what we think that we will direct you to act in accordance with the memorandum of settlement,
Memorandum of compromise.
taking note of the order of deposit interest amount.
Correct.
And inter se disputes may be settled as per different rights and remedies, separate right and remedy. Money will go to company, it appears.
Money has to come to me.
That is the.
Who are you?
I am TG Satya Prakash, who filed the writ petition, who got the order.
Lord, let the company
The
and Satya
redirection is
Prakash
to be paid.
file an affidavit before the court because there shall not be any further claims from the government. Let them file an affidavit before the court to the.
Who? Satya Prakash?
they'll
Subject to the
indemnify,
order,
yes.
we'll comply with that.
Satya Prakash.
Satya Prakash as well as the company, because company deposited the amount.
What undertaking?
Lord, because the company has stated clearly that they have withdrawn the authorization given to Satya Prakash in the year 2016 itself. Therefore, he is not entitled for the receipt of the money. Now the company is submitting to the court that they have authorized Satya Prakash. For that reason, I am requesting that let there be an order, to the effect that let the company as well as Satya Prakash files an affidavit undertaking that if indemnifying the government.
In what circumstances?
In the event, Lord, if there is inter se dispute, then company should not claim again.
My lord,
That can be done.
Yes.
my lord, if as per direction,
So far as I am concerned, my lord, I will file an affidavit that I will not have any claim against the state
Provide in the
as
order
per the
itself.
order of the,
If you provide in the order itself, then an inter-se claim will be settled in the appropriate independent proceeding.
proceeding. Anybody can have a claim, they have to prove.
Inter-se dispute which may arise despite the settlement about the payment of the amount of interest shall be settled by availing right and remedies independently in an independent process.
Now the settlement is between the two independent parties.
So as a government come in picture.
Government will not come
Now
into
we are liable to pay the AMD to
So-
the company.
So you have paid.
Now we are paying to Satya Prakash,
So
who
you-
was representing the company at that point of time.
Because company is endorsing payment to Satya Prakash.
To that effect, let them file an affidavit. Because they
But-
say,
It is not part of the record.
no,
my lord,
they said
based on that only that order is passed. No, my lord, thereafter we have withdrawn. First
they
we
have
have given
withdrawn the
authorization.
authorization given to Satya Prakash in the year
Then can you
2016.
file that authorization?
I will file an affidavit to that effect that I
My
will
lord,
not
let
have
him
any
file an
claim
indemnity.
over the state.
What you feel?
My lord, I am TG Satya Prakash. My lord, I will file an affidavit that I will not have any claim over the state in relation to the directions passed, both in writ petition number so and so and writ petition number 8533.
Understood. Who is company?
No, I am appearing for the company.
Ah,
You also file undertaking
that's
or affidavit that you have no objection to the payment to be made to Satya Prakash.
Satya
My lord, I have, that is the reason, my lord, I filed.
File the affidavit as you stated. You stated that you will also file affidavit.
Yes, I will file an affidavit.
So it will vouchsafe both ways.
I will file an affidavit in my individual capacity as the petitioner in writ petition number 8533, where there is a direction to deposit the interest amount which has been deposited and earlier amount has already been worked out. There is no problem in relation to earlier amount. Therefore, I in my individual capacity will file an affidavit that I will not have any claim over the state in
Correct.
relation to
Fair
this. That's all.
So
Nobody has come before this honorable court, may not claiming any independent right. And the so-called writ petition 3977,
This is
parties
only-
have compromised.
This is only because the direction given by Mr. Mahendra.
Yes, I don't know, my lord, what had transpired earlier.
You file affidavit.
I will file an affidavit.
he is
I don't know
receiving-
about the company.
Right, Mr. Mahendra. This is all in lighter. So both affidavits will take care of your state.
That's
My lord, company is not interested in the matter, money to go to Satya Prakash.
So the affidavit, what is wrong in filing affidavit?
My lord, your lordship,
Only that you are authorized, that you are the friend of Mr. Counsel. What is the good news? That is the affidavit you are supposed to file. What affidavit you will file? That you are a good friend of counsel and you will not claim anything. And you are authorizing him to receive the money.
my lord, if the order is complied, there is nothing survives because
But his writ petition itself is not maintainable. He is seeking the.
No, now we are on the affidavit.
Correct. I will file an affidavit because the review petition is against me.
Company has earlier withdrawn the authorization to pay to you. Now therefore, again, it should be renewed to the interest of the state that when you are.
Company has to file an affidavit.
my lord, I'll consult them because I don't know whether
You'll
they
have
are
to
ready
issue
to give or
directions
not.
to the
Because
company.
they are,
My lord, please
now
request-
they are claiming money should come to them. Company is claiming money should come to them.
If that is the case, Lord, the state is at, if we release the amount in favor of Satya Prakash,
1 minute.
My lord, as per this impugned order, when this writ petition was filed, the intention was to protect the depositors who have made.
You keep your affidavit ready.
I'll keep my affidavit. ready.
Going to file affidavit, keep it ready. Otherwise, we'll just go through the chronology and
My lord, your lordship may pass orders.
can
my lord.
understand from you what is the.
My lord, company may not file affidavit. Your lordship may pass orders, my lord.
Today, we are not going to pass.
Any
We are
day.
Not,
Any day.
I am not clear to pass the order.
My lord, when shall I file the affidavit, my lord? In the
Keep it on 9th of, not 9th, we'll keep it on
Whenever your lordship.
20. We give it on 2nd July.
Yes. Obliged.
Lord, then if the company is not filing an affidavit, then my review petition may be considered.
That will consider.
Yes.
On that day, we'll just, there is no headway as such in our mind, at least in my mind. When it is kept, 2nd. On 2nd, we'll dispose of it. It appears that
please.
nothing survives but for some miscellaneous things.
Obliged.
Worked out. Yes. Next. This is work number.
65, Mr. N. Kumar.
My lord, I appear for a complaint, my lord. I want to withdraw the petition, my lord. I filed a memo seeking to withdraw the
A1, Subramania.
The Honorable Advocate, Mr. So and so for the complainant has filed undated memo, which reads as under what this memo. In view of the proceed memo figuring on record, permission and request made to permit the withdrawal of the contempt petition, permission is granted, the contempt proceedings are disposed of as withdrawn.
This number 66, Mr. Suraj Nayak.
Same order. Memo dated 31/5/24, which reads that under court in view of above. Permission is paid for withdraw the contempt petitions granted. Contempt proceedings are disposed of as withdrawn.
So number 67, Mr. Subramania Bhattiyam.
I appear for the complainant, my lord. In fact, this is the matter your lordship heard 2 days ago and expressed the opinion that the order, the undertaking given by the council has to be complied with. So seeking.
My learned friend had given an information that one post was vacant in Puttur. In fact, that information that they have obtained is
Where
2
is
years
that
ago.
directions?
It is at Annexure D, my lord, page 42.
Page?
42. 42.
So according to vacancy is there,
Yes, your lordship.
vacancy is there.
Yes.
In fact, the information supplied by my learned friend is 2 years old and she said only one vacancy is available in Puttur Taluka. In fact, I have got the latest vacancy list. In which there are 3 vacancies, your lordship. Yesterday itself, a letter has been communicated to the government. 2 weeks' time may be granted, your lordship. We will comply with the order and show her a posting in Puttur Taluk. Now, there are 3 postings, C category posting where she's.
Very well, ma'am. Their submission may be taken on record and
On last occasion on 10/6/24, the court had an occasion to pass the following order. Court the order. Today when the contempt petition came up for consideration, learned additional government advocate, so Mohammed Jafar Shah held a memo.
Page 4, your lordship. Page 4 of the memo, your lordship.
Memo.
There are 3
Dated-
vacancies in
dated
Puttur Taluk.
Memo. full stop. He was unable to dispute the statement, dispute the case of the complainant that the vacancy is available. And stated that there's 3 vacancies are available.
3 vacancies are available.
Full stop.
Okay.
In that view, it was stated that it will be possible for the authorities to, in that view, it was stated that the authority will be giving appointment to the complainant in compliance of the directions of law and single judge. Full stop. Law and additional government advocate, however, stated on the basis of what is stated in the, what is mentioned in the memo that 4 weeks' time would be needed to finalize the procedure of appointment and giving posting
Transfer.
to.
It's just a transfer. They've
it's
already
not a
appointed.
transfer, my lord. In fact, it is a posting. I was working in Puttur Taluk only and By virtue of the order, they have given me the posting somewhere.
Necessary process.
Yes, yes.
Full stop. The statement satisfies learned counsel, Mr. So and so about the complainant. Any of the above statement made and stand taken by the authorities. Proceedings does not survive.
Let it be, let it not be dropped, my lord. Let 4 weeks time may kindly be given, and if they have not complied with, again I may have to initiate separate proceedings again.
Don't try to counsel satisfies. In view of the above development, don't put upon 1st July.
Very well. I'm grateful.
1st July is working? Yes, 1st July. To be listed as 2/3.
I'm grateful.
Yes, yesterday's matter.
Number 68.
My lord, acquisition proceedings was initiated by the state government for the purpose of grant of house sites to the weaker sections of the society. The complainants have challenged this acquisition and the writ petition was allowed. Hence, the acquisition was lapsed.
Allowed with which direction? Lapse.
Yes. And thereby, without the completion of the acquisition proceedings, they have used 38 guntas out of 1 acre, 28 guntas of
So
land.
here, you are here to comply with which directions?
My lord, page number 42.
44?
44, my lord.
Read it, last paragraph.
Yes. The above having been said, learned counsel for the petitioners is more than justified in insisting that the government should get the sale deed from his clients within a period of 3 months by making the payment as has been assured in terms of Deputy Commissioner's letter, failing which the petitioners would be entitled to the interest at the rate of 18% on the amount of assured to be paid by way of price for the sale, and the same shall be reckoned from the first day following the expiry of 3 months, and further that this excess expenditure incurred on account of levy of additional interest shall be recovered from the erring officials of the government and of the Rajiv Gandhi Rural Housing Corporation. My lord, my lord, in this, they had agreed to pay 4 times the amount, which is 1 crores, and it's been more than 3 months. A learned AGA appearing for the official respondents, page number 42, my lord, has already addressed a letter dated
26/12/22.
Yes, my lord. 42, my lord. Paragraph 3.
Lordship, I appear for the second respondent, Lordship. The land acquisition is of the year 1982, Lordship, and second respondent company was incorporated in the year 2000, Lordship. And even in the writ petition, we are not parties, Lordship. Here, the DC has sent the proposal to the Rajiv Gandhi Housing Corporation, but then the proposal was for 1 crore 44 lakhs, Lordship, for which we had to get the permission from the government, Lordship, and government has rejected the claim, and same has been informed to the DC, Lordship, much prior to the order of the present order in writ petition 244045. We have already informed the DC, Lordship, and our instructions to the DC has not placed before the court lordship. And we don't have any provision to acquire the lands lordship.
Land was acquired for the benefit of the corporation. The corporation has to pay. However, you should ascertain the view of the submission that my learned friend has made regarding the rejection of the proposal. I will get the information placed.
But you will be complying which directions?
Now, the compensation has to be paid after recovering from the corporation. It is acquired for the benefit of the corporation.
No. Corporation was not at all in existence as on that day, lordship. It is acquisition is of the year 1982 and corporation was incorporated in the year 2000, lordship.
So this last paragraph is complied with? Read the last
Compensation
paragraph.
has to be paid to the
Last, it hardly needs to be stated that the entries in the property records in respect of portion of the land to be retained by the respondents in view of the arrangement referred to above shall be restored and
Restored
that
back to the consent
it is done or not?
that I will certain and I'll.
Not
That
paid.
they have to. I will file a appropriate status report.
Do it, then why you are?
Yes, Your Honor. The two things regarding this, whether they retained portion and whatever is handed over to them, and also regarding the compensation. 2 weeks time may be granted, Your Lordship, I will file the status.
2 weeks will not grant. Now do it fast.
Yes.
Otherwise we'll require who is the person to comply with.
Deputy Commissioner myself.
You aren't able to throw light what steps you have taken. Yeah. Learned additional advocate, government advocate, pays for time. You take instructions regarding. Page 43. What is quoted in Kannada? 43. Beautiful.
As per the above explanation in 38 guntas of land, out of 1.28 acres in survey number 531 of Naganahalli village, Mysore Taluk, the Grama Panchayat has distributed 41 sites to the houseless eligible beneficiaries and houses are constructed in 38 guntas of land. Hence, it has decided to purchase the land as per guideline value of 36 lakhs per acre. 4 times of this sale price amounting to 1 crore 44 lakhs as a special case, hence requested for lease of the said amount. The district case committee in a meeting held that this decision is taken and the copy of the entire proceedings enclosed.
So what is your grievance now? Madam?
That they've not paid the amount.
Not
my
paid
lord.
the,
No.
it's 36 lakhs.
1 crore 44 lakhs.
Compensation.
Yes, they have not paid it.
In lieu
And
of,
there's been a lapse of 3 months already and
you are
they've
granting some land in lieu of that. You are granted some land.
we've occupied 36 guntas of the said land and we've agreed to pay 4 times that market value because we've utilized 36 guntas of,
In place of this,
yes,
what is awarded?
yes. So they've agreed to pay about 1.44 crores of it. And
4
they've
times the
not
value.
paid the amount still.
4 times the value of 36.
Yes,
So now what will remain for you to become, to be complained to you, for you?
that they've not paid the amount.
You're not paid. the-
Yes, and there's been a lapse of 3 months already.
You find out,
More than about a year, my lord.
find out.
I will find out and place the. same-
2nd July,
Yes.
2nd. Anything?
Seal number 69. Shailesh, yes.
PF order. Lord, I am an agriculturist having certain agricultural land. And the 5th respondent is starting has a stone crushing unit, which is facing north of my property, my lord. Initially, all the stone crushing would be done manually, but then they have installed machine cutting tools. Therefore, I have brought the present writ petition, my lord. My lord, what happened was, because the reason I have come before this court is because it is causing both environmental damages plus also health hazard to me. My lord, I have also produced, if your lordship takes my writ petition, at special page 40, my lord. That's a report by the health authorities, by the doctor. And the first sentence says, lung markings are prominent. Because the dust from the stone crushing unit goes up and it will fall on the agricultural land and also on the premises where I reside. Then, apart from that, please turn to page 46, my lord. The hearing assessment. Ringing sensation in left ear is what the doctor has prescribed. And then it says Susu PVSP, which I cannot understand, my lord. But this is the report. Based on this, I have come before this honorable court. What happened was, when I came before this honorable court, an order came to be passed on 2/7/2021, seeking for an inspection report to be carried out by the 4th respondent. That report, your lordship finds, the first report which has come is on 31/8/2021. Lord, if your lordship turns to the report, the first report which has come, at special page 5, sorry, the running page 2, 5, my lord, there is specific observations in regard to this matter. The stone crusher, may I read, my lord? The stone crusher was not in operation at the time of inspection both days on 9/8/21 and 10/8/21. The crusher representative informed that the crusher under repair and hence crusher is not in operation since last 15 days. The petitioner agricultural land was located adjacent to the stone crusher. It is observed
that part of the land located adjacent to the road has not been cultivated and other part of agricultural land has been cultivated with tur crop. Deposit of stone powder in the agricultural land immediately located adjacent to the stone crusher boundary has been observed. Noise and ambient monitoring was not carried out as the stone crusher unit was not in operation. This was the report which was submitted by the fourth respondent. Subsequently, my lord, this honorable court, when after the report came, passed one more order. This is on 14/2/21. There, a direction was given to the second respondent, Deputy Director, Department of Mines and Geology, to visit the stone crushing unit personally and submit a report. On second report, which was, so they went. So they went to the stone crushing unit. And a report has come. On 27/2/2023, your lordship turns to the second, the objections which have been filed. In that, your lordship finds the spot inspection report. That is at annexure R5. It is there in their objections. The translated copy is at page 21. It starts from page 21. The date is 27/2/23, but please turn to the next page, page 22, my lord, the last paragraph. Please permit me to read. Further, when conducted joint inspection of 3 acres 7 guntas of land, 3.707 acres of land of the complainant, Shivram Pujari, that is the petitioner, in survey number 107/3 of Tavregere village, Kalburgi Taluk district, adjacent to the said crusher unit in survey number 16/13, over an extent of 1 acre, the half portion in the east is wasteland, and it is found that no cultivation has been done in the remaining area. The dust of this crusher unit mixed with mud was partly found here and there. Further, it was found that there was no stone well in the said land, and at present it was filled with water, and it was adjacent to the stone well area. Tur dal crops were sown in a part of the area. This is the second report which has been submitted. This is as per the order of this honorable court on 14/2/23. Subsequently, what has happened is, without any order from this honorable court, once again, a third report comes to be filed. Third report comes to be undertaken. As I mentioned, that is without any order of this honorable court. Your lordship turns to page 30. That's a translated copy, the Mahazar report. At special page 31, paragraph 3, my lord.
Who will appeal?
I approve.
What is it?
That as per the direction of this honorable court dated 14/2/2023, a joint inspection was carried out in the crusher area and found that there was no violation as such. It is produced at annexure R7. And moreover, the crusher which was granted, license was expired on 31/3/2024. And we have not renewed the same since the writ petition is pending. And so far as the emission of dust and other things are concerned, they have taken all precautionary measures as mentioned in para 9 of the statement of objections. And the inspection was carried in presence of the petitioner.
You file your reply.
I have filed.
Yes.
On 6th April 2024, it was filed. Last, may kindly go to para 9. Page number 6, para 9. Internal page number 6. Flash.
It is submitted. There was a fresh joint inspection. This joint inspection is the third inspection without concurrence or without any order from this honorable court.
Read, Lord. Initially, my lord, this was granted in the year 2014.
Now, what is the prayer here?
Lord,
Prayer is what?
prayer is to Lord quash the license granted in favor of you.
In favor of somebody.
Lord, prayer is
Cancel the license granted in favor of fifth respondent.
apart from that, we also have, there is a second prayer for a mandamus to take suitable action against the fifth respondent for causing air, water, and sound pollution. There are two prayers.
So what are you showing?
My lord, two submissions I would like to make. Firstly, the fifth respondent has never appeared, though he has been served in this matter. Second submission which I would like to make, apart from the fact that the third inspection report was carried out without any specific order of this honorable court, is there is a violation insofar as the Karnataka Regulation of Stone Crushers Act of 2011. Stone Crushers Act.
This was heard also.
My lord, only one submission, please permit me. This act says any stone crushing unit should be situated 1 kilometer away from any cultivable land, from private land.
Day after tomorrow for orders.
Next matter, may kindly be permitted to
70.
withdraw the writ petition, please.
Withdrawing.
I want to withdraw the writ petition.
70.
Please.
Learned Advocate Mr. Shiva Kumar KB. Files memo. Dated 12/6/2024. It stated that it is stated that the petitioner is instructed to withdraw the writ petition. Now, as per the request, the petitioners, what are you withdrawing? Select Law and Advocate so-and-so. Shiva Kumar KB. I will say memo dated 12/6/2022, seeking permission to withdraw the petition upon instructions. Permission is granted. Petition is disposed of as withdrawn.
Please.
Number 16. Ramatullah Kutwal.
Appearing for the state, my lord.
For the petitioner, my lord.
Yesterday?
Yes,
Yes,
my
my
lord.
lord.
Yeah. Tomorrow morning.
My lord, I'll finish the arguments, my lord. Just a couple of things I wanted to.
Yesterday
please.
this was considered.
Please,
Yes.
please, your lordship had heard it day before yesterday and it was moved to
Yesterday.
yesterday and today. It's been listed today.
The same work member.
Bucks election.
Board elections, my lord.
My lord, if I can make the submission on behalf of the state. My submission, firstly, my lord, who is the petitioner herein? Whether he has the locus standi to maintain this public interest litigation. Does this public interest litigation merit to be entertained before this honorable court? And whether the issue which is in as part of the prayer in this writ petition, whether it has already been decided and whether the petitioner herein has approached this honorable court with clean hands, divulging whatever facts as per the public interest litigation rules of 2018. Firstly, my lord, the entire case revolves around the appointment of one Mr. Abdul Riaz. Now, this appointment is with regard to the Electoral College to the Bar Council. And with regard to this, my lord, the state of Karnataka, as per section 14, if I may just read section 14 for a moment of the Works Act. The entire controversy emanates from the appointment of Shri Abdul Riaz. There are two appointees now. Before I go into that, my lord, I would like to take your lordship's attention to section 14 for a moment of the Works Act. Section 14, my lord. Section 14 pertains to composition of the board. Now, this composition of the board for the state and the National Capital Territory of Delhi shall consist of a chairperson, that is A, B, one and not more than two members as the state government may think fit to be elected from each of the electoral colleges consisting of. Now, there are 4 electoral colleges. The question with regard to the controversy is B3, which is Muslim member of the Bar Council of the concerned state. So what has happened in this case, my lord, the state, by virtue of annexure R, has instead of one electoral, one member, has allowed and granted 2 members, which is permissible as per 14B. Because 14B gives the prerogative to the state, it can have 1 and not more than 2 members. So that is the impugned notification at annexure R of the first writ petition, that is writ petition numbered 13769. Annexure R at page 131. Dated 7/9/2020. 131, my lord, of the first writ petition, dated 7/9/2020, wherein the state has said instead of 1 member, we shall have 2 members with regard to the elections of Muslims of the Bar Council of the concerned state. Now, this is impugned in this writ petition. Now, pursuant to this impugned order at annexure R, the appointment of Shri Abdul Riaz was made after the election notification, that is 15/9/2020, and the appointment date is 16/12/2020, my lord. Now, 15/9/2020 is annexure V, which is also impugned in the writ petition at page 135, which is the notification which calls for the elections for this particular member. Now, the entire case of the petitioner is that there is only one Muslim member to be elected, and an ex-Muslim member cannot be elected. into the details. Now, all these issues has already been settled and looked into, and it has reached finality. Now, the petitioner herein, there are two sets of petitions that have been filed. The first set of petition was challenging the appointment. That is in the memo of compilation of judgments, my lord, they started with writ petition 10835. Wherein they filed a writ petition first initially. At page 19, my lord, of the memo of judgments. Memo of judgments, which was produced on 10/6/2024. Page 19, this is how the first litigation began. On 5th October 2020, the order was passed wherein the challenge was to the appointment, the challenge was to the notification, impugned notification 9/7/2020 and 15/9/2020, which is the election notification. And then they filed a PIL because there was the liberty given for them to file a PIL. So a PIL was filed, that is memo page 22, which was dismissed again on 19th November 2020. And this was filed by the petitioner in 16.1 and 16.2. That is Shri Asif Ali Sheikh Hussain, who is actually a elected member right now. There are two members. One is.
Very notification was under challenge.
Yes.
And upheld.
Yes.
Mr. Counsel.
Lord.
Withdraw, very good. Which one? 136769. 14330 of 2020. Learned advocate, Mr. So-and-so, upon instructions, seeks permission to withdraw the present petition. In that regard, he files memo. Dated so-and-so, which is taken record in view of the memo, seeking withdrawal of the petition, dismissed as withdrawn. Memo dated 12/6. So now, all are selling in same boat.
No, my lord.
The ones who have withdrawn had already come before this honorable court, which I had just mentioned with regard to the PIL and the writ petition, my lord. Now, the entire question would revolve around whether the current petitioner has a locus standi to maintain such a petition, public interest litigation, not bringing forth all these issues before your honorable.
You want to argue or they want you to argue? So what do you want now?
Lord, I'll
One
take
of
your
your
last,
colleague
I'll conclude within 3 minutes.
Some
my
is
lord.
down in one of your colleagues.
No, within 3 minutes, I'll conclude, my lord, by showing 3 different notification. The government has to
Different
change the
notification.
stance within 2 days, my lord.
Same issue, Mr. Counsel. Same issue, different notification, but same issue.
No, my lord. The same issue must be same, my lord. But initially they said 2, my lord. Again, they said 1. Again, subsequently, after some time, they said 2, my lord. The act is clear, my lord. Subclass 2. My Leonard Flood read the subclass 1, my lord. Subclass 2, I'll read, my lord.
Two advocates argue the same issue. One succeeds, one loses.
Subclass 2, she is conveniently
So,
avoiding
that can't
subclass
happen.
2, my lord.
There is nothing, all right, argue.
Lord, the election of the members specified in subclass 2 shall be held in accordance with the system proportional representation means of a single transferable vote in such manner as be prescribed, provided that where the number of Muslim members of the parliament, the state legislature or the state bar council, as the case may be, is only 1, such Muslim members shall be declared to have been elected on the board. So in this case, Millard, in the last election, there is only 1 Muslim member who got elected, Millard, by name Asif Ali Sheikh. So he should be the member of the bar council, work board, Millard. So the respondent number 5, Millard, he is being defeated by this petitioner, Millard. So he come by the back door by taking an advantage, Millard. There is no question of ex-member, Millard.
What is next?
I'll take your lordship kindly, page, my lord. 127, my lord. It's a gazette notification initially published by the state itself, my lord.
Where is it?
127, my lord, in my petition, petition number 13769. It's a gazette notification. Minority Welfare Hajj and Waqf Secretariat notification. Page 127, ink page, my lord.
Champion that cause. And if your lordship sees the amendments in the writ petition, verbatim same. So this is abuse of the process of the court. Whether they can be let off for this kind of abuse of the process is the only thing which I would like to bring to your lordship's kindly.
Point one, my lord, I may be permitted to file memo without.
Another one. Which is that? 10835 is disposed of. Which is the?
10835.
It is already disposed of. Disposed of. One.
Point two, I
Same
have
order.
filed, my lord.
same order, which was disposed of earlier. No, number. Oh, acha. 10835, same order as was passed in 1433 of 20.
Obliged.
You are the only person, you make us work hard. Dismissed.
Please.
Much
We'll pass the orders. All the reasons.
Memo for withdrawal, my lord, I'll file in the comment.
You are withdrawing orally, you can withdraw. Then go, then that separate it in, when you will get the memo? Within 2 days, get it on 18th, list the single out that and list on 18th. 18th at 2:30.
Number 17.
My lord, I favor for respondent number 2 to 5, my lord. Seek short accommodation, my lord. Arguing
Request, my
counsel is
lord.
not well, my lord. This is NHA matter, my lord.
Lord,
I appear for respondent number 2 to 5, my lord. I seek short accommodation, my lord.
Time.
Yes, my lord. She's not well, my lord.
Lord, may I request for a date, my lord, if my lord's.
PIL is.
Yes, my lord. It's a
NHA
PIL,
matter, my lord.
My lord,
Where-
what has happened, my lord? I have filed a PIL for completion of
PIL?
NH 209.
Completion of a road, my
Undertaken-
lord.
Of 2022.
Yes, my lord.
For
which was
completion of a
the
road, my lord.
work, my lord, which was undertaken in 2017. Till today, my lord, it is not been completed.
No, my lord.
Because
we
the
have
new
taken-
concessionaire, my lord, had been engaged in the year 2023, 4/8/2023. There's a new agreement executed by the National Highway with the new concessionaire, my lord. On 27/3/24, my lord, the new concessionaire had to complete the work. But until today, my lord, the
Lord,
work
there
has
are-
not been completed.
Work
my
is
lord.
in progress, my lord. I'll place the necessary documents for progression of the work, my lord. We may not.
Now the road must have been over.
No, my lord.
Not
Till
yet
today, the
completed,
road
my
is
lord.
not
Not yet
completed.
completed, my lord. Due to the change of the concession, my lord, work is under progress, my lord. I have filed the necessary report on 24/11/2023, my lord. The safety measures were taken, my lord. So hence, I need to file certain documents, my lord, where the work, to what extent the work has been completed, my lord. Hence, have it in next week, my lord. I'll place the records, my lord.
15/3/23, my lord.
Lord, the commissioner was
audited
also
15/3/23.
appointed, my lord.
After that, I filed in safety measures, my lord, on 24/11/2023, my lord. Due to the change of contractors, my lord, the work could not been completed in time, my lord. Work is in progress, my lord.
Filed a status report also, my lord, on the previous occasion. Kindly be taken on record.
So why it is not getting completed?
My lord.
Why the road is not getting?
My lord, what happened, my lord? There was a contract given to a company before, my lord, that for several reasons, my lord.
They
it was
couldn't
terminated, my
complete,
lord.
my lord. They could
It
not
was-
complete. Hence,
it was
we have appointed a
terminated, my
new
lord.
contractor, my lord.
On
I filed the record.
4/8/2023, my lord, a new concessionaire was appointed to complete the work. And the new concessionaire, my lord, had to complete the work by 27/3/24. That is March 2024, my lord. Till now, that has also not been completed.
No, my lord, the work is under progress, my lord. I will place the records.
From
To what extent the
2017,
road
this
has
is
been
what the
completed,
state
my
of-
lord. Due to the change of the contractor, it couldn't be done, my lord. Due to the change in the contractor, my lord, the work could not be done in time, my lord. Now the work is under progress, my lord. I'll place the records, my lord, to what extent the work has been completed, and I have even filed the affidavits of project director, my lord, to what extent it has been completed.
Learned advocate, Mr. So and so for the National Highway.
Yes, my lord.
Wants
Two to
to
five.
place on record the time-bound period within which
My lord, next date I'll file the necessary documents, my lord, to show what extent.
to respond to the grievance that the work in question of the road is getting prolonged and not completed. The highway.
Highway, man.
Highway. Such affidavit come according to learned counsel for the National Highway Authority shall be filed within 10 days. Within 10 days.
Obliged,
Send over to 3rd July,
Obliged, my lord.
4th July.
urgent, still number 19.
Lordships may kindly take 144 of 2023, that is 19.3 minutes. The matter, my lords, pertaining to a challenge to the notification dated 17/8/2023 as regards affixation, my lords, of high security number plates.
Oh, this is for only for extension of order.
Yes, my lords. The undertaking given by the government, my lords, expires today.
May I just make one submission in that regard? It appears the apprehension of the petitioners may no longer survive. They moved the vacation bench, my lords, possibly legitimately so, because on 21st of May, the deadline was 31st of May. So the petitioners moved the appellants moved the vacation bench, apprehending that extension will not be granted, and therefore their appeals may become infructuous. Be that as it may, that may not be relevant, but even assuming that is correct. Once I have instructions to submit, but that the state itself is now will issue a notification extending the deadline, possibly, I'm told, up to August, maybe even September. In fact, my lords, out of respect for this honorable court's orders, if my lords were to see the interim order passed, just that last paragraph, my lords, the order dated 21st of May, there is a restraint on us to take any further precipitative steps, action, or decision. So we can't even extend right now. So even if the state wants to extend the time limit, we may want to extend up to September is what I'm told. I can't even take a decision. So if my lords were to permit us to take that decision, that may be sufficient. The last paragraph was of 21st May.
So nothing to be extended.
Yes, my lords.
While extending the undertaking, your lordships
Till 12/6.
Your lordships may, while extending the undertaking, permit my learned friend's client, that is the state, my lords, to take a decision on the extension. I can quite see my learned friend's concern that because of the order of this honorable court, that no precipitative steps, action, or decision be taken. Perhaps that comes in the way of the state taking a decision on extension.
Absolutely.
My lords may continue this undertaking, clarifying that the state will be at liberty to take a decision on the matter of extension and place it before your lordship's lords whenever the state is ready with the decision.
Moment that
When on 21/5/24, order was passed, passing the following interim direction. Quote last paragraph, in view of aforesaid facts and circumstances. Paragraph. As per the above order, the appeals were supposed to be listed on 11/6/24. However, yesterday it was not listed. Today, the appeals came to be listed. Essentially, therefore, the appeals are before the court for extension of interim order to fix the next date of hearing. Full stop. With regard to the aforesaid order, as per the learned vacation court, application, Judge. It was submitted on behalf of the state government by learned additional representative Mr. Vikram.
Yes, ma'am.
What is the full name?
Surname, who will go, ma'am?
That by virtue of the aforesaid order, the state is restrained from taking precipitative steps and also from taking a decision in the matter. He submitted that paragraph. The decision with regard to the extension, fixation of high security reserved plates in the vehicles.
No. Registration, please, registration, please.
Plates in the vehicles in the state of Karnataka is required to be taken. Competent authority. Full stop. It was requested that while the state will not precipitate the matter, however, the decision may be permitted to be taken on the above aspect about fixation of HSRP plates. Learned advocate, Mr.
Aditya Sondi.
Senior advocate. So and so clearly stated that if the precipitated steps are not taken, the state may be permitted to take an appropriate decision and place the same before the court. Paragraph, any of the above submissions coming forth, the order dated 21/5/24 is modified to the extent that the state government is permitted to take a decision in relation to the fixation of HSRP plates, and such decisions will be placed on the record of the present proceedings. The rest of the relief about not taking precipitative steps and action shall continue to operate.
That will automatically follow, ma'am. The moment we extend the timeline, that follows.
Stand order when?
They come
But
from
that
Delhi,
depends on
ma'am.
how much time the state would want. I'm in your lordship's hands.
The council come from Delhi, ma'am. I won't, depends on how much Dr. Sondi were to.
No, when you are going to take decision, that is.
No, the decision, Malal, the state government will take a decision by end of the week, Malal. That a notification has to be issued.
Well, whenever, it's only for extension of time as far as.
Today it is only for extension of time.
May I request, notes that your lordships may also fix a date so that the appeals could be heard on that
That
date.
is what we are asking. When shall we?
Lords, 25th June, subject to your lordships.
25th June, there is a bench.
I see. 26th, my lords, if your lordship's board permits.
July, let it go in July.
As you lord.
9th July.
Please. Lords, could it then be a little later, my lords? 9th even for my friend may be a little difficult.
3rd July.
It's precisely why I said Delhi council.
Third.
3rd July, madam.
Reopening time is
2nd July.
2nd July. So obliged.
Is it all right? 2nd July.
Very well.
Would my lords like to keep it at 2:30, my lords? In the 2:30?
2nd July. We would like to begin at 11 when we are fresh.
Grateful.
My learned friend has some difficulty, but the week after, my lords,
If your lordships, my lords, are
8.
my lords, 8th is the reopening week in the Supreme Court, my lords. Therefore, I am making a very humble request. If your lordships permit, my lords, on the 2nd, we will make a beginning. Thereafter, my learned friend may be accommodated. It may not be completed in one day.
Fourth is okay.
fourth, if it's possible.
4th is.
Please. Grateful to your lordship.
19.4, I filed a PIL in the same matter, HSRP matter. They
That's
have,
okay.
the matters clubbed with the other writ petitions. Since the subject matter is different from what they are contending, I request it to be unclubbed and heard separate. I filed an VA for this.
Club and separate. You want to club or you want to separate?
It's already clubbed. I want it to be decoupled.
Lords, we are not parties in the PIL. Therefore, lordships may kindly keep the PIL with this.
Because
We
subject
filed
matter is
it.
different.
No,
That's why
because
it's
in fact,
question.
Malaz, if I'm not mistaken, the public interest petitioner was aggrieved by the fixation of a timeline. Now we're making a submission. So the list is
The
pretty
same
much.
day but separately.
Okay, sir. Thank you.
As your lordships. That solves the problem. So grateful.
Deeply obliged.
Number 20.
In serial number 20 and 21, my lord. My lords, the appeals were admitted, my lords, by the Honorable Court on 22nd of February 2024. Now an application is filed, my lords, by the respondent number 3, my lords, seeking early hearing, my lords, of the appeal. I have no objection, my lords, to the application. Lordship may fix a date, my lords, for hearing.
Date is fixed. Appeal, IA is disposed of by directing the registrar to list. First, what is that? Writ appeal. Writ appeal on 18 July.
Grateful. Great. 21 is also.
21 also.
21 also, my lord.
21 also, my lord.
21 is also. Sir.
21 also.
Number 22. Getting non-compliance, non-filing of complaints in contempt matter.
Number 2 to 5 in writ appeal 361 of 2023, my lords, 22.1. This morning I filed affidavit before the registry.
Last occasion, my lord, this came up on IA. My lord said, with understanding to be heard today, it's posted.
Let us start. You want to start? Not if you. It is what? This is contempt. What is to be heard in contempt?
Lordship, I have appellant in the writ appeal, Lordship. I received the copy just now to go through it. Copy nahi kotiರ್ಲಿಲ್ಲ.
But I have some urgency in this case, my lord, because I invested 10 crore. Tender is, my lord, notice of award is allotted to me.
Oh, she must, Ramsel must have time to read the.
Lord, understand, my lord, to hear this today, my lord. Not the on IA, because I have filed IA, advocate on record has filed IA for modifying the interim order. Last occasion came up, if your lordship, your order said it will be heard.
But you are filing reply to. Reply was filing.
No, my lord, I have not, in writ appeal, there is no procedure to file reply, my lord, because since we.
Writ appeal, you want to proceed?
No, writ appeal, they have filed the affidavit and I have to go through it. I don't even know what is there in this.
Okay.
Government. Government file affidavit, not.
Somebody is.
They are formal parties.
He wants to find out who has filed it.
No, difficulty is I am put to hardship, Lord, because an interim order.
At least reply is filed, that is undisputed. We'll keep earlier, 25th will keep. 25th.
It clearly, my lord. 10 crore is, my lord, I have invested on raw materials.
25th is very early.
Number 23.
24.
I appear for the appellant in the connected matter.
Yes. What happened? Decided. Representation is decided or readable to be argued. Readable, love.
But in the respondent herein has filed a writ petition seeking extension of UGC pay scale right from the date of her appointment dated to 28 December 1993. have prepared a short synopsis, my lord. May I pass on? Shall I take the lordship through this synopsis? That this petitioner was appointed on 24/8/1993 as lecturer of education in Shankaregoda College of Education, Mandya, which was affiliated to Mysore University on 24/8/1993, subject to condition that she should acquire required qualification within 2 years. Lord, at that time of appointment, this Shankaregoda College was not granted with aid. It was an unaided institution. On 28/12/1993, Department of State Education Research and Training approved appointment of respondent number 1 on non-grant basis. On 24/1993, this college was granted aid, was brought under the purview of granting aid by the government on 24/1993 with effect from 1/4/1993. On 2/9/1993, government approved the appointment. This is very relevant, Lord. On 2/9/1993, government approved appointment of 8 lecturers for granting aid, and the said government order, the name of the respondent was not included. That means to say, my lord, the grant was not extended to the petitioner as on 2/9/1993. On 4/5/1994, the government issued order extending UGC pay scales to the teachers working in college education with retrospective effect from 1/4/1993. In the said government order at para 434, directions were given that those are recruited in future should possess the following qualification or qualification prescribed by UGC from time to time. On 21/6/1995, UGC brought about an amendment to 1991 regulation by adding the following provision. Provided that the candidates who have submitted PhD thesis or possessed MPhil examination by 31st December 1993 are exempted from eligibility test for lecturers conducted by UGC, CSIR or similar test accredited by UGC. Last may kindly see. Minimum qualification for extension of UGC pay scale is National Eligibility Test Exam, NET or SLET. However, there was an exemption given those who have passed PhD or passed MPhil examination by 31st December, this is the cutoff date, 1993, are exempted from eligibility test. Thereafter, on 31/7/2002, UGC issued first amendment to the University Grant Commissioner qualification, minimum qualification required for appointment and career advancement of teachers in universities and institutions affiliated to it, regulations 2000, titled University Grant Commission, minimum qualifications so and so, by which whenever the following para occurs, NET shall remain compulsory requirement for appointment of lecturer, even for candidates having PhD. degree. However, the candidates who have completed MPhil degree or have submitted PhD thesis in the concerned subject up to 31st December 1993, again, prior to 31st December 1993, are exempted from appearing NET examination. Lord, I'll pause for a moment. I'll take your lordships to the qualification acquired by the petitioner in the last but one page of the same synopsis. Lord. The qualifications of respondent.
Lord, these are all not an issue at all. Lord.
So you are not fulfilling the educational qualification
Lord, that may not be an issue. But
on the
kindly
date
see
of,
an-
on which
Lord,
date?
Yes, kindly see not that.
On cutoff date.
what
Cutoff
might-
date.
what
The
might
last may
for-
kindly see the qualification acquired in the
Lord, it is
synopsis.
an annexure E. Lord,
Synopsis,
Lord, and
last but
MPhil
one
Lord,
page.
MPhil obtained on 98, not 2008.
Cutoff date is 93,
93,
December 93.
December 90. And Lord, there is a,
Now that is provided in which UGC regulation? Some scheme, clause, in some clause, condition, term?
yes, Lord, UGC regulation dated,
Annexure N1,
amended amended on 21st June 1995. So also in the amended UGC regulations, 2002. The UGC consistently maintained, Lord, NET or SLET is must for extending UGC pay scale. Even in the impugned order, Lord, the learned single judge, without adverting to this aspect, your Lordship may kindly peruse para 10, page number 36 of the impugned order. In the circumstance of the case, this court is of the considered view that in absence of material which would indicate that the petitioner whose services are regularized with effect from 28/12 to 1993, he is justifiably denied the UGC pay scale with all consequential benefit in terms of the order dated 4/5/1994 and 1/2/2011, and in the backdrop of her claim, as aforesaid, the petitioner's grievance cannot be adjudicated, and the effective consideration would only be if such government order are referred to and applicability thereof justifiably explained in the circumstances peculiar to the petition. However, Lord, while ordering, Lord, the learned single judge directed to regularize her service, in the light of her regularization from 28/12/1993, UGC shall be extended, it was the order. Then page number 11, the impugned order must be quashed in so far as it restricts the extension of UGC pay scale to the petitioner with effect from 28/4/2000. We have granted you extended UGC pay scale from 28/4/2014. That is the date on which she acquired SLET qualification without due consideration. And the second respondent must be called upon to consider the petitioner's entitlement to UGC pay scale in the context of regularization of her service with effect from 28/12/1993. From as on 28/12/1993, the college itself is unaided college. UGC cannot be extended. And her case that she was duly qualified as per the government order dated. The government order is inconsequential, my lord, when UGC prescribes qualification for extension of UGC pay scale, as held by the Honorable Apex Court in Raj Singh's case.
Statement of objection were filed in?
No, ma'am.
Not filed. Here reply is filed.
Yes.
Here reply is filed.
You only stated that the statement was made in opposing the prayer, stating that necessary qualification was not there. Then the learned judge has, he has also.
Here it is stated itself.
Yes. So these all the issues were not raised before the learned single.
No, we have produced documents. We are seeking to produce additional documents also in this appeal, which has bearing in consideration of this claim of the respondent. All that I am requesting is plot. The matter may be relegated to the authorities for.
Which authority? Which authority?
To consider whether.
But that is what the learned single judge has done.
To learn a single, no.
Yes.
No.
Kindly similar. Learned single judge has directed the authority to decide that.
Decide the
Kindly
issue
similar.
with
He has not
reference to
granted-
the observation made in the.
Yes, but he has not granted the relief to me, but he said what they had granted from 2014 may not right, but also consider her request because retrospectively her appointment has been done from 93. That's all they said in terms of annexure A, K, not because I had a qualification as on that date. Their grievance is, their defense is that I don't have qualification of net or slept or on the so-and-so date, 93. But learned that specifically said as on the date was not necessary. It is from 2009 onwards. That is what annexure N1, kindly similar annexure N1. It is after from
We are
2009.
aggrieved.
Yes, that is the only issue. my lord.
We
That
are
is what.
aggrieved by the order of the learned single
no,
judge
my
to
lord.
the extent that Lord, consideration shall be on the basis of the observation made, that is with reference to annexure K.
May I make one request? Ma'am? But kindly see, I have agreed by annexure F. Lord, I have filed before the court. Kindly see annexure F what they have said. My friend, Lord, apart from that, he is raising all the issues of what the authorities have considered, annexure F. But I have before the court for questioning annexure F. Kindly, their only thing is Lord, that I don't have a necessary qualification, post-graduation qualification in chemistry. But that was not the requirement as on annexure K. It is there, my lord. Kindly see, my lord, annexure F. In the writ petition, page, my lord, that is 76.
So they were granted from 20 benefit.
They were granted from
2014.
28/4/14. What was the date, that significance of it? Passing of some exam?
SLET, Mala.
That is
State eligibility test. SLET she has passed
from 2009 onwards. Annexure
on
N.
KEST exam. That is called KEST exam on 28.
So we are clarifying this, that observations will not come in.
That's all.
That may not.
Normally, whenever the matter is remanded, it is entirely.
But
kept open for
that issue may not, he can't ignore that issue, but we'll have to consider all the aspects.
No, we'll consider all the aspects. We'll consider all the
Well,
aspects.
that is what I said.
The
Kindly see,
challenge
madam.
in this.
May I make one request? now my friend has, what has raised, they're all not an issue which I have before the writ petition. What annexure F? Not kindly see annexure F. The authorities have said, kindly see that annexure F. The authority said, I possess MSc degree in chemistry as on the date, so I am not entitled for this benefit. That is the only issue they have raised. Kindly see that annexure F. Page. That is the only issue they have raised. Then the learned judge annexure K, the qualification refer. Yes, she had a qualification BA, BEd or MA, MEd. That is the qualification, not necessarily MSc. So consider from the date of her appointment. Kindly see that annexure F. The learned judge has the order passed by, say, they have also produced it is vernacular. My friend has also produced the typed copy of the translated copy.
Some earlier petition was read.
Yes, my lord. Earlier, what had happened was, since this petitioner was not brought under the grant in yet state pay scale, Lord, by mistake, she has been paid state pay scale, Lord. Ultimately, Lord, the audit department raised objection. Though she was not granted aid, she has been paid the state pay scale. We have stopped the state pay scale then. That was challenged by the petitioner in the earlier round of litigation. Then this honorable court, Lord, set aside that audit objection and directed us to pay the state pay scale.
Not Lord, regularize the same from the date of her appointment. Kindly see annexure A, Lord. This court order.
The challenge in this writ appeal is directed against judgment and order dated 10th January 23. On a single judge.
Lord, may make one, just clarify 2 points. Lord, from 93 she has been appointed. Lord, since her appointment was not for rise, some objections were raised. Lord, we have approached this court. Lord, this honorable court, by this honorable court, my lord, on 1st June 2018, regularize the same. Sorry. It is actually, this court has directed them to regularize the same. Not accordingly, it has been regularized. Not from thereafter, not the joint director recommended that we are having a necessary qualification for to grant UGC pay scale from 1993. Now they said, I don't have that courses, short-term courses prescribed by UGC from until 2014. So from 2014, I am entitled for the same. Now I have questioned before the same before the learned judge. This is the only issue. And another issue is I don't have a post-graduation degree in chemistry in as on before 2010, which I have obtained. Hence, from 2014, I am entitled for the same from the date I have passed the UGC courses. The learned judge said.
On what basis you are claiming from 1993?
From the date of the appointment, which this court has issued, and they have issued an appointment order from 93. Annexure DE before this court issuing my appointment order. That is what the annexure C is saying. And
so where is that rule or something you are showing?
This is annexure N1
along with the
which will support your case.
Page number, Lord, 132. Relevant portion is, Lord, in 134. General, clause 6 under 7.
Yes.
As from 1/6/2009, the teaching staff who have not acquired the qualification prescribed by UGC are not entitled for availing the benefit of UGC revised scheme unless they acquire NET, SLET, PhD. No MPhil.
So it is in 2016.
Yes.
1669.
Yes, ma'am. From 1609.
He joined when?
Yes.
1993.
1990?
1993.
And I became eligible when?
In the year 2014.
That may not
be. No. That is for passing, by passing.
Yes.
So
for extension of UGC pay scale. She has passed KEST exam on 28/4/2014. And we have extended UGC pay scale from 28/4/2014.
Which exam you passed?
KEST, Karnataka eligibility, entrance eligibility test.
But 93, such a qualification was not there. But kindly see, but just annexure K.
The challenge in this,
May make annexure K just for a moment, for my satisfaction. Just, but what was the qualification on which I am, when the UGC pay scale was extended? What was the qualification? Kindly see, that I am having on that. Kindly see annexure E, my qualification list I have produced. But as on that date, I had that qualification. That is the reason I kindly see that annexure K for a moment, page 89. Page 89.
page 89.
Yes, annexure K. Now, revised UGC pay scale has been extended on 4th June 1994. Page 89. Now, as on that date, now from 1993, my appointment has been issued retrospectively from the in terms of the Supreme Court order. Now, from 93, kindly, as on that date, kindly see what was my qualification, which was necessary for granting the coverage. The coverage, the scheme applies to the teachers working in all the aided colleges, clause 1(4), clause 1. Coverage. The scheme applies to the teachers working in all the aided colleges of education, B.Ed, M.Ed colleges, claiming under control of commission, so and so. Now, date of effect, 1st April 1993. Then, kindly come to pay scales. Then, qualification. Come down to the Roman 3. The scales will be extended only to those persons who have the qualification of BA, BSc with M.Ed or MA, MSc with M.Ed or M.Ed. What my learned friend is referring from 2009, not as on the date where the UGC revised pay scale has been extended to me 93. 93, this was the qualification. Kindly come to next class, lecturers in College of Education, what we recruited in future should possess the following qualification or the qualification placed by UGC from time to time. Second class master degree with 55% in any subject, B.Ed or M.Ed, with 55 marks. I request all to kindly come to annexure E, my qualification. Page 72. But I obtained the B.Ed in 1989 with 66.37%. M.Ed in 1990 with 59.12%, and MA Sociology in 98, MPhil in 98, MSc Chemistry in 2010. But I had the qualification as on that day. That is why I learned single judge. Please consider that. Page 72, my qualification. Now, Joint Director has recommended my case, not 69, page 69. Joint Director recommended I am entitled from 1993 because I am having a qualification in terms of annexure K. Now, page 69 is the recommendation by the Joint Director. Now, the government has given a go by only on the ground that you don't have a personal qualification, post-graduation MSc, and that is why you are not entitled from so and so. Now, thereafter, they said before the court that NEET and SLEPT exams were not passed, but that was from 16 to 19, not retrospectively. This is the only issue that they will have to reconsider in the light of these orders and the government orders. That's the only issue that they will have to look into along with other issues which I am entitled or not. Page 69 is the recommendation by the joint director. No, they have granted from, as my friend contended, no, they have granted an HRF from 2014. That is, if they one will have to acquire from this refresher course or internal courses prescribed by UGC from 2009, not retrospectively to 1994. 1994, such a prescription, such a conditions were not there. So what my learned friend say may not right. So let the authorities consider in terms of the learned single judges order.
Then what next? Anything further?
No, that's all.
The challenge in this appeal at the state, at the instance of state is directed against judgment and order dated 10th January 23. Whereby writ petition filed by the respondent petitioner can be partly allowed. Full stop. The operative directions paragraph issued by a single judge, reads as under court page 37. The petitioner in his writ petition prayed for petitioner who was a professor in the subject of chemistry, lecturer in the subject of chemistry, working under the respondent Shankare Gowda College, Mandya, by filing writ petition, prayed to direct the respondents to grant the revised University Grants Commission in UGC bracket over pay scale from the date of regularization of her services with effect from 28/12/1993. The benefits were granted to the UGC pay scale benefit was granted to the petitioner lecturer. However, from 28/4/14, it was the date when the petitioner passed. Karnataka eligibility test to KET. The grievance of the petitioner is that he was entitled to the UGC pay scale from 28/12/1993, which was the date when he came to be appointed. Honored government advocate, Mr. Mahendra. He had a limited but succinct submission to Canvas to SSL the directions. What he submitted was that although learned single judge has remitted back the matter for consideration by requiring the petitioner to file a representation, the direction is that the decision shall be taken. Direction is to take direction to the authority is to take decision in light of the observations made in the order. It was submitted in this context that though the case is sent back, the decision is almost preempted, since the authority would be required to decide within the four corners of the observations made in the order. On the other hand, learned advocate Mr. So and so for the respondent original petition supported the judgment in order of learned single judge to submit that he was entitled to the UGC pay scale from 1993 only. Full stop. It is pertinent to note that the eligibility clause from the UGC guideline entitling the teachers and lecturers to receive the pay scale reads as under Roman 6, page 134. Blue. It is in light of the aforesaid eligibility prescription by the UGC that the right of the petitioner lecturer to receive the scale would be required to be adjudged. Full stop. As far as the contention of the appellant state, that while remanding the case, from a learned single judge has tied the hands of the authority by observing that the decisions taken shall be taken in accordance with the observations made in the order, would be countenanced. It is tried principle that when court remands the case for reconsideration or for deciding it afresh, the court is not supposed to express opinion either way. Full stop. All the questions of merit has to be left open to be considered by the authority which is supposed to take a fresh decision. Full stop. The court cannot impinge upon the discretion of the authority in taking decision and considering the merits, the rival merits, when it would be its domain, to consider the controversy and render a decision. Paragraph. In the aforesaid view, the present appeal deserves to be allowed to the limited extent. It is clarified that the second respondent shall consider the representation of the petitioner independently and without influence by any observation made in the order of law and single judge. Full stop.
But including that observation, including that observation.
It goes without saying that.
Yes,
the
including that
authority shall-
observation.
The authority
because-
shall take into account the contentions on both the sides and decide the
Yes,
matter.
all the
after.
issues.
Full stop. All contentions are kept open to be agitated, to be raised by both the parties. Full stop.
Right.
Above clarification.
And may I make one request, let that be a time-bound program, because otherwise, it's 23, it was passed an order. Right, she is retiring the age of retirement. Let them consider, and we have 4 weeks
It's
time
further
was granted.
provided that the competent authority shall decide the representation and take a fresh decision expeditiously and within a period of 14 weeks from today.
Connected contempt.
Contempt does not survive. in view of the writ appeal having been disposed of by order of the one date. The rights of the party shall be governed by the decision taken by the
Obliged.
authority as directed by this court.
Deeply.
Number 24.
But it says that compliance has. There's an interim order existing in the writ appeal filed by me, my lord.
What question is whether resolution can amend the rule. Learned Judge held, my lord, according to rules, please the consider the case of promotion of the official. Watching the resolution. And this, my lord, the order at page 37.
Whether the resolution considered by the learned single judge amounted to a fresh amendment, or is it only giving clarity to the existing notification is what is to be considered. To that, the relevant points with respect to the
Which
rules,
order you are challenging?
the order dated 21st March 2023 of the single judge here. Wherein, if your lordship, the honorable court at paragraph number 7, ink page number 31, internal ink page number 31 of the paper book, appeal paper book, your lord. The contentions are just what were placed before the learned single judge here. Learned so and so, for the petitioners primarily contained the rules have been in give as for providing seniority come merit subject to the availability of vacancy, and therefore in order to ascertain the seniority, qualifying services shall be reckoned from the date of initial entry into services in terms of the notification dated so and so annexure A, and the same cannot be clarified, modified or deleted by way of a resolution dated so and so annexure F. Accordingly, certain judgments have been relied upon. Per contra, next page, paragraph number 8. Per contra, so and so appearing for the corporation sought to clarify the impugned resolution dated so and so and submitted that the amendment has been made to the regulations referred to the above by incorporating the word circle insofar as the employees working in the respondent corporations are concerned. In that view, the matter, he submitted that in order to maintain the uniformity in promotion, he referred to the amendment in annexure R1 to the statement of objection. He refers to clause 12 of the said regulations and contended that whenever an employee is voluntarily transferred to another circle, then the seniority of such transferee shall be considered in accordance with the circle wise of the regulation, and accordingly he sought to dismissal of the writ petition.
Now the order is at operative part is paragraph 16.
Is at ink page number 38 of the paper book here.
No. Order under challenge in writ petition is what?
Writ petition before this honorable court, the writ petition order starts at ink page number 23. The operative portion of the single judge's order is at ink page number 38, my lord.
Annexure F, my lord, page 130. It's a resolution amending the rules. Rules are there at page 67. And you see both.
Now you are
Annexure F.
arguing what?
Annexure F.
Writ appeal or what?
Writ appeal, my lord. Writ appeal. I'm sorry, my lord. I think I did not make that mention. Pardon me, my lord.
Which order is under challenge in writ appeal?
Yes, my lord. Writ appeal, the order under challenge is annexure, page number 23, the order dated 21st March 2023.
Page 38.
Operative portion is at page 38, my lord.
So that is the order whereby the It is only directed to reconsider the case. What more? What is
Lord.
to be challenged?
I'll just make my submissions clear on that particular aspect. Yes, your lordship is very clear that it is for reconsideration. Whether that reconsideration is in consonance with the clarification made to the notification. This is a circle-wise promotions what is being given, Your Honor. The person, if your lordship to that particular aspect, may I draw your lordship's attention to ink page number 130 of my paper book, my lord, annexure F of without certain observations, if the learned single judge had made out that it should be reconsidered or what, yes, it would have taken place. But the resolution where the single judge sets aside a resolution which was a clarity or a clarification in nature, wherein the entire state, by virtue of a notification, the entire state, whether it is circle-wise or state-wide, it had to be take place. RNP regulations had to be take place. For that, when there were clarifications sought from each circle-wise, the board, the matter had to be placed before the board, Your Honor. And board clarified what it had to be clarified, what were the clarifications sought from each circle-wise. If your lordship is pleased to appreciate the resolution, my lord, at page number 130, subject matter before the board was 132/17. Resolved that the approval be and hereby accorded to issue necessary clarifications to continue to follow the existing transfer policy and issue clarifications as under. My lord, if an employee who is working in one circle opts himself to get over to another circle, his seniority comes to the lowermost. That is what it says. I have just got documents. If my lordship permits me, a person who voluntarily wants to opt his services to another circle, he cannot be on par with the persons who are already employed in that particular circle. Their seniority goes to the bottommost here. At the time of appointment, these are the undertakings we have the employees have submitted, Your Honor. This is with respect to petitioner number 1. Lord, may I read out the translated portion with the memo which I have just placed on page number 3, my lord. Pradeep, assistant lineman working as transmission lineman, Udupi, translation. I have been transferred on intra-circle transfer basis as per the above referred order, accepted so and so. I have executed a bond of on this date as per the order. Lord, a person who accepts or is voluntarily gets transferred from one circle to another, his seniority reckons to the bottommost here. So that was what was made out. When the notification for under 12B1 was made out, certain clarification, as it was a statewide notification, certain clarifications were sought, Your Honor. For that, the board took it up, the matter was placed before the board, which is the primary body under the KPTCL, which resolved that and gave a clarification to that. That was under challenge. Earlier, if your lordship is pleased to appreciate, ink page number 132. First, a fresh batch of writ petitions were filed. The present petitioners before the single judge were the respondents in that particular writ petition, Your Honor. And agreed, certain people agreed by that notification were before the Honorable Court. Then, if your lordship is pleased to appreciate, ink page number 145, my lord, of my paper book, my lord, the earlier round of proceedings, Your Honor. For a moment, if my lord bears with me for ink page number, the order of this Honorable Court starts at 132, the relevant and the Page number 145 for a moment, my lord, of my paper book.
So it is a promotion to the post of
Assistant lineman, junior engineers, my lord, from the rank of lineman and assistant.
So what is the criteria of promotion? Rule?
Yes, my lord.
10% will be by promotion, those who have acquired diploma qualification. Rule says seniority is concerned, thus senior shall be considered from the initial date. Kindly take page 67 rule. What rule says? Then we will come to resolution.
Page 67.
67.
Promotion, yes.
Kindly see below note. Seniority and qualifying service shall be reckoned from the date of initial entry to service.
Correct.
And the person who is transferred from one unit to another unit, his seniority from the date of initial appointment. Unless this rule is amended,
The appointment to the transfer place.
transfer. Transfer. What happens? Suppose a storekeeper, a lineman, from Kolar to for example, Bangalore, he will be transferred.
But the initial entry of service.
Yes, my lord. His qualifying service shall be from initial appointment.
His transfer will not change the initial.
Notwithstanding transfer, my lord.
That is what the single judge has made. That is what is prohibiting us from continuing this 2 lakh order. Transfers to be made by law.
So rule is not questioned. What Leonard said is, your rule says this. You cannot amend unless rule is amended by your resolution. You cannot amend the rule. That's all the.
Say tomorrow will come.
My lord?
Tomorrow will come.
For a moment, I can.
My lord, serial number 47. Serial number 47 is.
Serial number 63, my lord. I am appearing as party in person. There is some urgency because counseling is likely to start anytime. PIL, which I have filed, JE results have been announced, NEET results have been announced, CET results have been announced. I have sought for a direction.
Yes.
Serial number 50. Yeah, tomorrow I will come. Tomorrow, my lord. Not for stay.
2 weeks.
My lord, 46.
Friday.
Serial number 30, my lord. Serial number 30. She is litigating more than 5 years, my lord. So getting the compensation ground appointment. And last occasion, my lord, honorable court is positively directed to consider her case for appointment, my lord. More than 5 years, my lord. So the positive director is also there. He has not filed the reply, my lord. The accused is not filed the reply. Tomorrow, my lord. Since 5 years, my lord, her father is, she has lost her father.
Serial number 50.
30. My lord.
He's saying what I have to be extended.
Serial number 30.
Interim order.
No, interim order, my lord. The consideration of contempt matter, my lord. Contempt matter. Reply statement I have not filed, since last 5 years, my lord, she is litigating. And positive orders also passed by the honorable court, my lord.
Tomorrow
Appointment on compulsory ground.
Tomorrow has already come.
Day after tomorrow, my lord.
46.
Serial number 55, my lord. Midway through the course, 7 months into the course has been removed, my lord. So the date for the next year is also lapsed, my lord. I those 2 years, my lord. It's contrary to the notification that she has been removed. For the PG Ayush course. The internal exams are also coming up.
It is today.
It's listed today 55.
55.
Kindly we had tomorrow.
When the exams are going.
The end of this month.
End of this month. Then.
Lack of attendance also, they will not give us the.
Then. 19th.
My lord,
Office.
Lord, I have filed the list of dates and the synopsis.
Office objections are dispensed with.
My lord.
File this synopsis, you not.
I have filed the synopsis and list of dates. Lord, they said to file synopsis in chronological order. Lord, I
My
filed
lord.
both.
In matter serial number.
Serial number 54.
Do it. File it in chronological order.
I have already filed the synopsis and the list of dates.
Very good.
May,
My lord,
40,
serial number 54, my lord.
Interim order may be
Serial number 54, my lord.
but interim order may be extended when there is an office objection raised that the.
All of his within 3 weeks, yes.
46, my lord, one matter in 46. It's a committee appointed by this honorable court to check out the G category sites, my lord. The chairman is only there's an,
Allow me to serve the copy of the writ appeal.
my lord, 46 may be taken over somewhere in the first week, my lord. There's some urgency.
My lords, a medical education matter, serial number 47.
Everything is ended over to court office.
My lord, 46.
47, there is urgency, my lords.
46, there's some urgency, my lord.
Medical education matter, there is a direction of the Honorable Supreme Court.
It's only a direction which needs to be for an appointment.
Lord, serial number 47, medical education matter,